Do you understand that if we were to proceed to trial in this matter, and if you were found guilty, the lowest permissible sentence that the court could levy in this case would be 22.5 years in the Department of Corrections? Do you understand that? Ma'am, understanding the state's offer, do you wish to accept or reject the state's offer to resolve this case?
Reject.
Welcome back. My, oh my, a lot has happened in a very short amount of time. Wow. Yeah, as we just saw, Miss Sarah rejected a 15-year plea when facing 22 and a half to life, min to max. Wild, but actually wild, because this is the deal of a lifetime, literally, and she rejected it. I have a lot of theories for why, how, what this whole thing is about, but I can't get over it. I honestly did not think that she was going to get off for a plea, not when we are this close and everything was about to get set off. I understand that plea deals are always on the table because you want to spare the families of the victim and those who are affected from the trial, because there's never a guarantee and a lot can happen and it can be very traumatizing. I understand that. I personally just didn't expect it. And I definitely did not expect the plea to be that low. But yeah, again, Miss Sarah got absolutely everything she wanted, and it's still not good enough. I need to take a side. I need to go to a side. I need to pause everything. I need to give Mr. Owens his props. Mr. Owens, I have been very hard on you. I don't regret that, and I don't take back anything that I've said, but I have been very hard on you. However, hearing this plea deal, Mr. Owens, you did that. You did that. Miss Sarah would not have gotten this deal without you, honestly, because one, she couldn't talk to the state herself. Two, they would never probably negotiate that with her because they already know she would never accept it. But he set all of this up. 15 years, have to do 85%. I believe Bruce Rivers did the math, and she could have been out in less than 6 years max. And just threw it away. Now she's risking a minimum of 22 and a half years. Bruce Rivers also brought up a good point about she loves to flaunt around her son, how much of a good mother she is, this, that. Anytime that she can throw that child up as a prop, she will do it.
Worried about my dogs. I was worried about my son. I went to my former husband's residence where my son was located.
You were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right.
My son can't come over here because he's here.
I know he doesn't live here.
He doesn't live here. Oh. I want to see my son. It's not fair.
Okay.
I can have my son come over?
It's your house.
My son out of school.
That's fine.
We will definitely make sure that you don't feel scared when we leave here, okay?
And
When we
my
leave.
9-year-old.
Well, he's at school and he's with your husband.
I know. Well,
ex-husband.
Oh, okay, Mom. I don't know what it is.
Exactly. And that's what we're here to find out. We're just here to get the answer. The answers that you want, the answers that his family's
I
going to
just
want.
really want to see my son. I really need to see my son.
Everything else, I have no idea what it is. No idea what it is. Nonetheless, I've had my son over the house, too, so why is it you all think that y'all don't know me, you don't know me, nope, would do something like that, especially having a 9-year-old son? I don't think you all understand who I am, where...
Okay. Well, tell me.
I mean, I've always been a straight-A student. I am an outstanding mother to my son. Okay. I excel at everything.
And if she had taken the deal, she would have missed 6 more years of that child's life, and then she could be a part of his life. But no, she's only thinking about herself, and now she may never see him again. I cannot imagine, even if you think you are innocent, somehow after filming it and admitting yourself that that is awful and admitting yourself multiple times that you did the deed that ended this man's life, if you still think you are innocent, you still take that deal. Mind-blowing. So good on you, Mr. Owens. I don't know who else could have done that, but you did that. So good for you. I will give you that props. Unfortunately for you, you are now going to have to struggle through this entire trial, but we get this. This was your goal the entire time. You wanted her to take this plea. That's why y'all keep getting in those shouting matches at the jail. I heard there was another shouting match. And when the people bust in the room and they said, what's going on? He took the blame for it and say, sorry, it was me, won't happen. Highly, highly doubt it. I would not be shocked if those arguments were over these discussions. Take the plea deal. It is the best thing you will ever see for the rest of your life. And when she's in that prison cell, she is going to be kicking herself every single day. Wow. And whenever someone like her rejects a plea, they always have to put it on the record. So they would do it like this. Because of the publicity, you know, the whole thing is now a production. But normally this is pretty common. And they put that on the record, so after she's convicted, she can't just say, oh my goodness, no one told me about this. I definitely would have taken the plea if only someone had told me. No, now it's on the record that you 100% rejected the plea. You don't get to just change your mind and say, no, I want to accept it now. No, you rejected it. Meaning, I think you have to propose one yourself, and the state has to accept that. Or you have to hope that they send you another plea. If they don't do that, you don't get to change your mind and take this specific plea anymore. And at first I was so angry at the state because I'm like, that is such a slap in the face to give such a low plea. And then I heard, I can't remember on which channel, but it's like some prosecutors will offer really, really good pleas. Once they know who this person is, they know 100% she is not going to accept any plea because she would have to admit that she's guilty. And everything that is inside her will not allow her to see or admit that she is guilty until someone else has to do it for her. They know that about her. So they are offering the absolute best possible plea she could ever hope to ever see, knowing she's still going to turn it down. And that's exactly what she did. I'm hoping that was the case. I'm hoping that was the case. I would only accept it if I found out that they had spoken with his family and that they were like okay with this plea if they didn't have to go through everything that has to deal with a trial. And I'm sure they're also offering a good win because if she did accept it, that means the publicity around their whole courtroom, everyone involved, all of their families, whoever's associated with them, yada, 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 because people are just bored and just be looking into people. They would not be affected. But she rejected it, and now we're going to trial. And on that positive note, let's transition into what this video is actually about. This video is covering all of these recent documents that just flooded and happened and are kind of important right before trial starts. So I wanted to get this out and then just look through everything. So this has to deal with the judge's order on the motion to suppress, the makeup bullshit, the makeup BS, the motions in limine, people's responses, a whole lot of things, the state's theory of how things happen. And honestly, when I was reading that, it just like drained and broke me a little bit of just, yeah, we'll get there. I feel like now I have to add a disclaimer now that more people are starting to see me a little bit. These are all of my opinions. I am not asserting any authority over anything on this channel. So I am just giving my opinions. Take what you take, leave what you leave. That's okay. It's all welcome here. Some other ground rules. Yes, I refer to her as Miss Sarah Paulson because that is her birth name.
He's escaping! The killer is escaping! Help me!
And unless I am reading it in a court document like I have to do in a few minutes, I will be using Miss Paulson, Sarah Paulson, Miss Sarah, any combination of it. Second, I will be using George Torres, George pronunciation. Why? Because that was his preference, and we learned that on a clip from body cam footage where a police officer asked him what he would like to be called, how he would like to be referred to as, and it was George.
You go by Junior, you go by George?
George.
Is it George or is it Jorge?
Jorge.
Jorge. All right.
George.
Hey man, I'll call you by your name. Well, you want George? Okay, I'll call you George.
So we're going with that. With all that, I think that covers everything. So let's jump right in. Alrighty, order on defendant's motion to suppress defendant's statements at OCSO, on defendant's amended motion to suppress defendant's statements at OCSO, and on defendant's second amended motion to suppress defendant's statements at OCSO. This cause came before the court on October 2nd, 2024, on the defendant's motion to suppress defendant's statements, e-filed 9/24/2024, the motion, on the state's motion to strike defendant's motion to suppress statements at OCSO, and state's response to defendant's motion to suppress statements, e-filed 9/27/24, the response. On the defendant's amended motion to suppress defendant's statements at OCSO, e-filed 9/30/2024, the amended motion, and on defendant's second amended motion to suppress defendant's statements at OCSO, e-filed 10/2/24, second amended motion. The court, having reviewed the motion, having reviewed the response, having reviewed the amended motion, having reviewed the second amended motion, having reviewed the court file, having considered the testimony and evidence offered by the parties, having considered the arguments offered by counsel for state, and having considered the arguments offered by counsel for defendant, finds as follows. A. Defendant Sarah Boone is charged by way of an information filed 3/23/2020 with a single count of second-degree murder. B. On February 24th, 2020, defendant called 911 after finding her boyfriend, George Torres, deceased. C. Deputy Kayla Rodriguez arrived on February 24th, 2020 and spoke to defendant. See also State's Exhibit 1. D. Detective Kopsel, a homicide detective with the Orange County Sheriff's Office, OCSO, with 6 years experience as a homicide detective and a law enforcement officer since 2023, was the lead investigator of George Torres' death on February 24th, 2020. Detective Kopsel arrived at the scene within 30 minutes to 1 hour of OCSO deputies arriving, was briefed, and performed a walkthrough of the apartment. Thereafter, a search warrant was drafted. E. Detective Kopsel then made contact with the defendant outside of apartment for a few minutes and explained procedures of the search warrant. The search warrant was executed with CSI. Defendant's cell phone was collected after CSI documented the scene. Detective Kopsel wanted to go through defendant's cell phone to corroborate defendant's story. Defendant signed a consent prior to the November 24th, 2020 interviews addressed below. See also Defendant's Exhibit 1. Detective Kopsel did not look at defendant's cell phone, including any videos, prior to the interviews addressed below, as digital forensics did not arrive until approximately 7:00 p.m. Detective Kopsel then made contact with defendant's ex-husband, Brian Boone. Thereafter, Detective Kopsel and Lowen had an interview with defendant in Detective Kopsel's unmarked Nissan Pathfinder at approximately 5:00 p.m. See also State's Exhibit 1. Detective Kopsel explained that she wanted to have conversation with defendant after walking the apartment. Detective Kopsel testified that she would not have interviewed defendant outside of the unmarked vehicle, had no memory of using the words routine, and that everything was explained on the recording. The word routine is not used by Detective Kopsel in any recording. See State's Exhibit 1. Now this is Judge Kranek just laying out all of the facts and before he really starts to break things down. But you already see at the very, very end, he says routine is not found in any of the recordings. So now is the time he gets to call out all the lies. F. Detective Copesell explained the purpose of this interview, including defendant's prior conversations with Deputy Kayla Rodriguez and Detective Copesell, and Detective Copesell's desire to get a further understanding of what happened last night and ask defendant more detailed questions. See State's Exhibit 1. Thereafter, Detective Copesell began reading Miranda as follows. Detective Copesell, I am going to read you your rights, but it's just because that's how we do things, okay? So you do have the right to remain silent, okay? Do you understand that? Defendant, yes. Detective Copesell, anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one, one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? Defendant, no. Detective Copesell, do you understand what I read to you? Defendant, yes. G. Thereafter, Detective Copesell interviewed defendant again after the initial digital recorder's memory was full. A second separate recording was initiated. Detective Copesell confirmed with defendant that no additional communications occurred prior to the second separate recording, and Detective Copesell inquired of defendant prior to asking any other questions. You do understand that you don't have to speak with me if you don't want to, correct? To which defendant responded, yes. Oh, there was a footnote I missed. Oh, it's in G. A second separate recording was initiated. 2. During this second separate recording, defendant used higher tier words, including compos mentis. So she used compos mentis in that second recording that we never heard. Hilarious. And then she repeated it multiple times the next day. Of course. So Kranik is basically not allowing her to back out, being like, I didn't understand what was going on, squashing that. I was still drunk. I think I was hungover and this and that. No, you weren't. Not on any of those recordings. You sounded exhausted and manipulative, but you didn't sound drunk. And for how many times she flaunts around her intelligence, he's not going to let her back away from those words either. H. After concluding the interviews, but before leaving, Detective Copesell had conversations with the defendant about coming to OCSO the next day to address the pending autopsy and that Detective Copesell would have more questions. Detective Copesell did not recall speaking about defendant's cell phone, but had defendant asked about getting the cell phone back, Detective Copesell would not have given a specific time frame for returning defendant's cell phone. Yeah, this is the conversation that Sarah claims is when they said they would give the phone back, they would come back to her the next day, hand deliver it, take her dogs out for a walk if she needed it, bring some hot cocoa, anything that she might have needed for her comfort and to feel better about killing her boyfriend. They were going to do it the next day. That's what she claimed this conversation was about. Chelsea claims it was telling her that we will have seen the autopsy and we might have more questions for you. So come down, da 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 da. And I imagine that Sarah did ask about her phone. I believe that. But I believe Chelsea would also give a neutral answer of like, yeah, we can talk about all of that. And yeah, she may have even said you can get it if you come down to the station the next day. But I think that would be the extent of it. Not this whole grandiose story that is almost impossible to believe. And it's like, come on, at least be reasonable with your lies. Stretch the truth, not completely create a new reality. Not me teaching her how to lie better. Detective Copesell had no memory of receiving a call from defendant on the evening of February 24th, 2020. I. Defendant's testimony largely agreed with Detective Copesell's testimony, including the timeline of calling 911, speaking with Deputy Kayla Rodriguez, and speaking with Detective Copesell. As to the February 24th, 2020 interviews, defendant confirmed that Detective Copesell explained that general questions would be asked. Defendant confirmed that she stayed on the scene 10 plus hours while the investigation was performed. Defendant's own testimony was that she was under the influence of alcohol from the night before at approximately 100 p.m. the next day. However, There was nothing evidencing defendant being intoxicated or under influence of alcohol when clearly speaking and interacting with Deputy Kayla Rodriguez. J. Defendant's statement of making a call to Detective Copesel between 9:30 p.m. and 10 o'clock p.m. on February 24, 2020 from her ex-husband's home does not line up with the defendant's own timeline of staying at the scene 10 plus hours, which began at approximately 1 p.m. The court finds this statement lacks credibility. Also, I'm dropping the military time. I'm just going to convert it. Kranick got up there and said, "Lie detector determined that was a lie." He said, "I'm not trying to mince words. Lacks credibility. You're lying. And this is going to go against you later on. You are already proving to the judge that you will lie on the stand." Not a great first impression as a testifying witness. K. Defendant claimed that before they left the scene, detectives Copesel and Lowen would return defendant's cell phone to the apartment. On February 25, 2024, defendant claims that defendant and Detective Copesel had a conversation regarding the picking up of the defendant's cell phone. Specifically, that due to Detective Copesel's pregnancy, defendant needed to come down to OCSO to pick up the cell phone. Defendant's sole reason for traveling to OCSO was to pick up the cell phone. Sure was. That was the only thing on her mind. Even though that's not what she heard, that's what she heard. She heard, "We would like you to come down because we will have seen the autopsy, we'll have more questions, and then we can answer any questions you might have. Maybe we can talk about what's going to happen to your phone. As I go down there tomorrow, I get my phone and they'll let me come home." And then had the audacity to say at the end that y'all tricked me down here. Can you imagine trying to tell someone, how did they trick you down here? They said I could come get my phone. Those monsters. That is such a stupid reason to get caught, because that's 100% what was on her mind. She interpreted that conversation as, I go down there tomorrow, I get my phone, they won't ask me any hard-hitting questions about what happened because I said it was unintentional. They'll believe that. They'll answer any questions I have, including how I can get back the engagement ring that I put on his finger before locking him in the suitcase. They'll reward me for coming to them because I did a service by going to them. They'll pat me on my greasy head and then they will send me on my way. Ooh, we have footnote number 3. We'll go back to it. The court finds defendant's statement regarding picking up the cell phone also lacks credibility. 3. Approximately 1 hour and 27 minutes into the February 25th, 2020 interview, defendant returns to her list of prepared written questions and specifically asks, "Am I getting my phone back?" And there it is. I read these filings and then I go back and react to that video, so I know what's coming, but I don't always know what's coming. But yeah, she came on there with handwritten notes asking for the engagement ring, asking about that parole officer that she was in love with, asking about what she does with the DV plans, asking what should she do about the funeral. That still absolutely blows my mind that it would even come out of her mouth that she would ask, how do I go to his funeral? You know, the person who caused the funeral to be necessary to be had. How do I get there? How can I center that around me? How can I speak at it? Because you know she would have tried to speak at it. Could you imagine? If that family jumped her, not a single soul would stop them. Which means she was just sitting at Brian's house the night before, thinking of questions to ask them. And this is what she landed on. This is what was most important to her. Nothing about George, nothing about his family, nothing about anything even remotely regarding him, as in you helping him in some certain way. Maybe it's, how do I get his belongings back to his family's house? How do I don't know, try to be helpful in any way. But no, it's, how do I get something for me? Me. And then she asked a million times, And I'm sure that was on her list of questions because she followed it up about what did they tell his family. That's probably why she really went in there. She wanted to know, what did they tell them? Because in her mind, she was going to be able to leave that day. And she said, I want to go back home and I want to prepare. She wants to know, one, what they know, what they think happened, and what they told that family, because she needs to know if she needs to get the hell out of Dodge or if she can just lay low and wait for it all to blow over. I can't believe she said that either. And those questions just reveal her priorities and her mindset, and will also, in my mind, be used against her, as in the day after this happens. You go there only for your personal gain and only to ask your questions. But now you are telling us that they tricked you down there and you made all of these statements involuntarily to the point where you want to throw them all out because the police tricked you into talking to them when these were the questions you had written down. I hope they confiscated that too. Maybe put that into evidence. I don't know. See State's Exhibit 1. This prepared written question would not be asked if one was told to come pick up a cell phone. Period. The court finds defendant's statement regarding picking up the cell phone also lacks credibility. L. On February 25th, 2020, after Detective Kopsel reviewed some of the extraction of defendant's cell phone by digital forensics and attended the autopsy, Detective Kopsel requested defendant to come to OCSO's office. Oh no, have I been saying this wrong? Oh no, that says OSCO, but it's OCSO. Typo. Anyway, Detective Kopsel did not want to approach defendant in front of her child at her ex-husband's home. Defendant's worry and concern about her son was addressed with Deputy Kayla Rodriguez. M. The state and the defense agree that the February 25th, 2020 interview was custodial. 9. The pith of defendant's argument is contained in this exchange during the beginning of the February 25th, 2020 interview. Detective Kopsel, just let us know if at any time you need water, okay? I'm going to have you sit in the green chair. Detective Kopsel, appreciate you coming in. Cutting in real quick. I don't understand. Every time someone tries to quote this video in a transcript, they always misquote it. I do not know who is not sitting down just to write it down or why they're skipping some things, but every time, no one has said this. She says, I'm going to have you sit down in the green chair that doesn't move. It may not be a big thing, but that's what she says. And I'm like, if I'm the defense, I'm also going to harp on that, being like, they put her in a stationary chair because they did not want her to feel like she could go anywhere. I don't know why they keep missing that.
I'm going to have you sit in the green chair that doesn't move. The green chair that doesn't move.
Defendant, yes, ma'am. I also want to ask about these when you have a moment. Referring to her pre-prepared written questions, Detective Kopsel, sure. So obviously he received his autopsy. So I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it. Just like we did yesterday. Defendant, normal protocol. Detective Kopsel, just like we did yesterday. She is the only one who keeps bringing up the word protocol. She actually heard the word protocol the day prior from the male officer when she was bugging him, trying to ask, why is this all happening? All because of hide and seek. Not because I was scared for my life and only defended myself, but did intentionally mean to kill him, but whatever. And he responded, this is normal protocol.
Are you guys serious? Like, this is really bad. Just from playing hide and seek.
This is protocol, man. We have to follow.
And now she's projecting that on everyone told me that, including Chelsea. I also went back and looked at a clip, and she actually said that she wanted to talk to them. Before they did her first interview in the car, they said that after they had finished all their stuff, they would come back to talk to her. And she said, yes, please. Yes, please. I would like to talk to you. I would like to say all of the statements to you. But now it's all coerced and involuntary.
So like I said, I gotta go do some paperwork. They're gonna chat with some people, and then we're gonna come back and talk to you if you're okay with that. You're okay with that.
Remember I read you the rights? Defendant, yeah. Detective Copesel, yeah. It's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? Defendant, sure. Detective Copesel, all right. So you have the right to remain silent. Anything you say may be used against you in court. You have a right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one, one can be provided for you before questioning and without charge. Has anyone threatened you or promised you anything to get you to talk to me? Defendant, note. Oh, there was another footnote. Okay. 4. The court notes that this statement is an accurate statement of the law. See Wright v. State, while Detective Stroop said, this is something I have to do when giving the Miranda warnings. This is an accurate statement of the law, as law enforcement officers are required to administer Miranda warnings prior to custodial interrogations. Detective Copesel, and do you understand what I just read to you? Defendant, yes. See States Exhibit 1. 1. Whether the Miranda warning sufficient. O. The Fifth Amendment of the United States Constitution and Article 1, Section 9 of the Florida Constitution both provide for a right against self-incrimination. Rickerton v. State. The self-incrimination clause of Article 1, Section 9 Florida Constitution requires that prior to custodial interrogation in Florida, suspects must be told that they have a right to remain silent, that anything they say will be used against them in court, that they have a right to a lawyer's help, and that if they cannot pay for a lawyer, one will be appointed to help them. Trailer v. State. P. Both the Florida Supreme Court and the United States Supreme Court have stressed that there is no talismanic incantation required to ensure that Miranda warnings are sufficiently conveyed. Miller v. State, a court does not examine a Miranda warning, quote, as if construing a will or defining the terms of an easement, quoting Duckworth v. Egan. Rather, the inquiry is simply whether the warnings reasonably conveyed to a suspect his rights as required by Miranda. Alterations in original, quoting California v. Prysick. The crucial test for determining whether police gave a proper warning is whether the words in the context used, considering the age, background, and intelligence of the individual being interrogated, impart a clear, understandable warning of all his rights. Quoting Coyote v. United States. Q. The Miranda warning provided by law enforcement to defendant at the beginning of the February 25, 2020 interview is sufficient under both federal laws, Florida v. Powell, quoting Miranda v. Arizona, and Florida law, see Thomas v. State, and State v. Owens. Okay, we have a 5th footnote. Now, where did that go? 5. In 1966, the United States Supreme Court issued its opinion in Miranda and established 4 warnings that are required prior to questioning when a person has been, quote, taken into custody or otherwise deprived of his freedom of action in any significant way. Specifically, quote, a suspect must be warned prior to any questioning, 1, that he has the right to remain silent, 2, that anything he says can be used against him in a court of law, 3, that he has the right to the presence of an attorney, and 4, that if he cannot afford an attorney, one will be appointed for him prior to any questioning if he so desires. R. The Miranda warning given to defendant in the instant case is identical to the exemplary Miranda warning identified in Owens Supra. S. As such, the Miranda warning given to the defendant in the instant case was sufficient.
I was waiting for Miranda to come in there and nobody came in there. I was waiting for her. That's right. Ain't nobody Miranda me. Miranda wasn't even in the room.
2. Whether the defendant's statements on February 25, 2020 were coerced. T. To establish that a statement is involuntary, there must be a finding of coercive police conduct, Baker v. State, quoting Schwoenwetter v. State. Generally, To determine whether a confession is involuntary and coerced, a court must examine the totality of the circumstances surrounding it. Martin v. State. When the voluntariness of a confession is in dispute, it is the state's burden to prove voluntariness by a preponderance of the evidence. Harold v. State. U. There were no misrepresentations of the law regarding any defense. See Johnson v. State. No quid pro quo, no directly or specifically made promises, no overt act or threat of force against defendant was proved or claimed, no fear of material or physical harm. See Grant v. State, quoting Denmark v. State. No hope of material reward, no indication that defendant was a newcomer to the law based on the 2 times Miranda warnings were provided between February 24th, 2020 and February 25th, 2020. United States v. Watson. No indication that defendant is mentally deficient, especially considering the verbiage she used. No threats, delusions, deceptions, or promises. See Martin v. State. And defendant was offered water and breaks. See Chavez v. State. She sure was. They brought her water at least 3 or 4 times. And then at the very end, when she's getting arrested, she's like, and I need water really, really bad. I need water really bad. Because she just wanted to have control over the officers one last time before they locked her up for good. Either that or she is one of the most dehydrated beings known to man. Probably because of that salty-ass attitude. Just the osmosis takes the water out of her like a raisin. V. There were no false statements made by law enforcement in order to coerce defendant to go to OCSO's office on February 25th, 2020, based on the findings above. W. Under the totality of the circumstances, defendant's statements on February 25th, 2020 were not coerced. 3. Whether the defendant's statements on February 25th, 2020 were voluntarily made. X. A statement is not compelled within the meaning of state or federal law if an individual voluntarily, knowingly, and intelligently waives his constitutional privilege. See Miranda v. Arizona. Quote, the state must prove by a preponderance of the evidence that a defendant's Miranda rights were waived. Barger v. State. To constitute a voluntary waiver, the state must show 1. That the waiver was the result of a free choice on the part of the defendant and not the product of intimidation, coercion, or deception. And 2. The waiver was made with a full awareness of the nature of the right being abandoned and the consequences of the abandonment. Only if the totality of the circumstances surrounding the interrogation reveals both an uncoerced choice and a requisite level of comprehension may a court properly conclude that Miranda rights have been waived. Why? Factors relevant to consider include 1. The manner in which the Miranda rights were administered, including any cajoling or trickery. See Miranda. 2. The suspect's age, experience, background, and intelligence. See State v. SLW, quoting Fair v. Michael, Doer v. State. 3. The fact that the questioning took place in the station house. See Drake v. State. And 4. The fact that the interrogators did not secure a written waiver of the Miranda rights at the outset. See Sliney v. State, Trailer v. State. Z. The Miranda rights were administered in a normal tone and cadence. There was no rushed or urgent speech. See Chaffin v. State. There was no delay in the administration of defendant's Miranda rights. The recorded February 25th, 2020 interview reflects that defendant understood and acknowledged that she understood her rights. See State's Exhibit 1. Defendant acknowledged that she understood her rights. CID, see Sliney v. State. Evidence supported conclusion that defendant voluntarily waived right to remain silent and obtained counsel when officer read defendant his rights and asked defendant whether he understood each of his rights, to which defendant responded affirmatively. AA. The court reincorporates its findings in U and V, herein which further show no cajoling or trickery. BB. Defendant was 42 years old at the time she made the statement and appears to be of normal intelligence. See also footnote 2 above. CC. The February 25th, 2020 interview did take place at OCSO's office and no written waiver was secured. DD. Under the totality of the circumstances, defendant's statements on February 25th, 2020 were made with a voluntary, knowing, and intelligent waiver of, and this waiver was the result of a free choice on the part of defendant and was not the product of intimidation, coercion, or deception, and that the waiver was made with full awareness of the nature of the right being abandoned. Orders and adjudges as follows. 1. The motion, the amended motion, and the second amended motion are hereby denied.
Bon appetit!
Done and ordered in chambers at Orlando, Orange County, Florida, this 3rd day of October 2024, the Honorable Michael Kranick. So yeah, we pretty much knew this would happen. The motion to suppress was denied. It was probably one of the weakest arguments you could come up with, but you did find something. I'm sure she hounded you saying you have to try, you have to do anything. You have to try in general, but I mean, try to be a little realistic. That 9th Miranda question, the absolute last one at the dotted line, was your last hope. It's what you bet everything on for this motion. And then it comes to find out that on the written waiver she had to sign, the 9th question was right there. It's not the detective's fault she didn't read. That's why it's there. It's there for her to read and then sign. So she was made aware. She just wasn't paying attention. Moving on. Order on defendant's motion for right to hair, cosmetics, and civilian clothing without restraints for trial. Okay, gotta pause already.
Sometimes I'll start a sentence and I don't even know where it's going. I just hope I find it along the way.
So in my last video, I did not cover the entire hearing because it was taking too long, and I cut it at the end of arguments for the motion to suppress. I said that I would put it in the next video. Here's the next video. So now I will insert whatever they said about the makeup there, and then we will finish with this order that happened afterwards.
Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. State what, if any, positions do you have with regard to the restraints?
Again, we've already decided that issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already, and unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
And Judge, I just want clarification, but, you know, she's here today and she's in handcuffs, so she has difficulty writing, she has...
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger, and people automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over?
No, that's your table, sir.
That's my table, closest to the jury. So she'll be sitting here with the other 2 lawyers and I, and the only time they're going to see her walk in and out is she's always going to be in the courtroom.
They're never going to see her walk in and out.
So,
Exactly. I don't know why he's acting brand new. He knows this. They keep bringing up, they have the privacy panels up front. The jury will not see her. She will not be walking in or out freely. She will always be at that table before and after the jury walks in and out. Traditionally, she'll be there shackled before they even walk in there. So there's no way that she could be heard. And they have little fuzzy things around the ankles so that the chains don't make noise. Unless she really tries hard, and she probably would, to make them be heard, there's no way the jury is going to know. He knows this. This isn't his first case. He's just trying regardless. And, I mean, he's going to be successful. That's the thing about it. We saw her at this last hearing. It didn't really help. It didn't help at all. We know she got new clothes, but did she? Here's my thing, side tangent. If I were her, I'd be upset. I'd say the first time I finally get to wear some outside clothing in 4.5 years, and you got me in this same drab navy blue. Ooh, I got something interesting happening with the sleeves. Hold on. Everybody better buckle your seatbelts. But no, I would have been like, put me in black or something. Just not the same exact color you wear every single day. And then I heard she wasn't allowed to have different shoes, and that she had to wear her jailhouse slides that she always brings up in her letters. That is so funny. I didn't even think of that detail. But of course, yeah, you have to get it done for every single detail. You got your new clothes still in the jailhouse slides. That is hilarious. I still can't believe she rejected that plea.
The only time is when she testifies. So I guess that only, I don't know if you have leg restraints that she can wear and walk, but we believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny. And she's walking from the defense table to the witness stand to testify on her own behalf. But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here?
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. You know, there are times...
Sir, you do not even know her. You have known her for what? A little over a month? I don't really think you are in the best position to determine whether she is dangerous or not. You know who else didn't see her as a danger? Moving on.
Times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative.
The lies we tell ourselves. If she's always been polite and cooperative, why have y'all already gotten into shouting matches to where literal guards had to come in and break y'all up? I guess you mean in the courtroom. She's been snarky as fuck, but I guess she hasn't been violent or threatening. That still doesn't mean she isn't a risk. She has shown defiance. She has shown pushing back. She has shown vitriol to what happens around her when things don't go her way. But everyone just ignores that because whatever. And that's really, truly the danger with her specifically and other people of similar backgrounds and similar MOs. People look at them and don't think they're a danger, which is why they are so dangerous. They get a pass because, oh no, it's fine. They wouldn't actually do something until they actually do something. Or it's not actually that bad until it's actually that bad. And she's used that. She's leaned into that belief all of her life so that she can keep getting away with this stuff. She can claw him up as much as she wants. She can shout as much as she wants. She can push, she can pull, she can scream, she can yell. She can do any of these things. And it's not really serious. That's just her defending herself. That's not her doing anything wrong. When he does it, it is, I am in fear for my life. But for her, you have to downplay and just excuse it all. And Brian is guilty of doing this during their marriage and 20-year relationship as well, but he was also over twice the size of George. So, yes, she wasn't as much of a threat to him. And honestly, I think that's why she went so hard at George, because she's used to just attacking someone who's twice her size and doesn't fight back. So then when she started attacking someone who is her size, actually a little smaller, and fights back, now y'all are just brawling back and forth because you can't believe this is happening. And so that's why the police have to get called, because he means it for real. When you do it, you're just being you, and we're just going to downplay and ignore it all. I know, sorry, we ended up in another world, but that's the whole point of this in my mind. She should be shackled up because other inmates would be of similar backgrounds, especially criminal rap sheets and what she's been arrested for in the past. It's not like she has had no violent past whatsoever. If she hasn't, then I understand that. But because she has, just ignoring that sticks out to me. It is another special treatment just because people are looking the other way. Would they look the other way if she did not look or present the way she does? You can answer that.
And she understands the importance of behaving, and I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue. His beliefs.
All right, thank you very much. With regard to your request for clothing in that, you could certainly go to the jail and provide, have whoever it is that you want to meet with her in the meeting area to provide, get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But
y'all made this whole big stink about being able to go to the jail and take her measurements and sizes in order to do this and to do that. And that's what you put her in? Just a regular shirt. Why could she not just tell you her size? I thought y'all were going to at least get her a tailored blazer or something. No. Then what's the point of any of this? Just to say you can or could or will or... But whatever. Go ahead. I'm sure they're waiting to pull out the finale looks for when trial actually starts. So, I'm not going to judge too harsh based off of one look. However, for all of the mess you're making us go through, you better turn it out a little better than what you did.
clothing will have to be dropped off at the jail, and it'll be transported with her in the morning each day of trial. With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial. Just the arguments in there.
And the Estelle case that you cited spoke to being dressed out in a prison garb. Doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
I just think it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm going to have the two paralegals here. I say the paralegals. One's a lawyer now, and the other is a consultant. But
his paralegals. Had to backtrack that real quick. I'm starting to believe the rumor that the two girls were both of their daughters, Mr. Owens and Mr. Henderson, because I remember Mr. Owens said that his actual daughter, also named Sarah, was becoming a lawyer. So maybe she has officially become one. And then Mr. Henderson's daughter is the other consultant. So I guess those are your hair and makeup team. That's your professional wardrobe. As long as you're not costing Florida more taxpayer dollars to try to get this, have at thee.
They're females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Can she be allowed? Can the two females on the team, can they be allowed to apply some type of makeup to Ms. Boone?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but
If you want to try to do it here in the courtroom, that's fine. But be advised that, when we start court, we start court. So, and I intend on starting it at 9 o'clock every morning.
So she has that quick little 10-15 minutes before court starts for the two consultants to try to put her in a full glam makeup, hair styling, all of the works. I mean, if that's the case, what's the point? If you're going to be putting on the makeup in front of the cameras, you're going to hate that even more, because then the shady cameraman is going to zoom right in on you, watching you put on some fake lashes. I don't think that's the vibe you're going for. I guess unless you think that you need to get done up specifically for the jury. If I were you, I would try to focus on the jury not looking at me as much as possible. That's just me. I don't think any jury member is going to see, oh, look at that pop of red right there. That means she's innocent. Gotta be. But waste your time however you like it. I know then she's going to be mad at the guards. Get me inside. Get me in there. And then what happens if one of them messes up? You're just done. I mean, odds are they're going to do something just very, very simple. Maybe just some tinted. I don't know. I don't really get makeup that much. But they're going to do a little something to zhuzh it up just a bit. But it will be delicious to watch.
So I'll have pleas every morning in other matters because the court still has other business at 8:45, and I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can have someone attend travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request to removal of the leg restraints. But the hand restraints will be removed.
Judge, and then I think there's something about hair as well.
I think that it falls under the same analysis.
It needs to be done in the courtroom.
Yes, sir. And then the last item teed up for today is the, oh, I'm sorry, yes. Yes. So corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband, they don't know what's placed on her person. That's the concern.
It's just going to be some facial makeup.
I understand, but
I don't see.
DOC and sheriff's officer telling me they can't do it.
I can't stand when people hear stuff like that, when it's like, I just told you someone else set this rule, and now I am relaying to you this rule, and you're like, well, I don't think it should happen that way. I'm just telling you what they told me. Why are you going back with me? You know this is not one of those, you just tell me your feelings, and then we get to overwrite the protocol that we have down for everyone else. Come with some solutions. Okay, if they don't like her going back with the stuff on her face, can we wipe it off before she leaves? You say that we get to let her get dressed and undressed downstairs. Can she get some makeup wipes and just take it off down there or something? If it is that dire, if it means that much to you. But just saying, I don't feel like that's an issue. Oh, I'm sorry. And again, all of these little things have to be taken into account when you have every camera honed in on you. So all the I's dotted, all the T's crossed, little things that you think they should just let slide, they shouldn't and can't, and at least need to make sure that it is known vocally, verbally, on the record that this is not what normally happens, so that the next person who walks in gets to say, I want this, I want that, you should let me come back in a full beat, I should be allowed to wear makeup 24/7, yada 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 yada. Plus, we don't know you. We don't know what you're going to put on her face. I mean, we trust you because you're an officer of the court and all this and all that. However, the guards can't just make that assumption about anyone or just let that slide. So yeah, come with solutions, not with problems. That's the motto I live by.
Because of the concerns that were just outlined after she's returned to the Orange County Jail facility.
Okay.
So that was what I didn't cover in the last video. That was her motion for this hair makeup. We already know she gets it because of what we saw. Now we're going to just read the official order and see how he phrased everything. But yay, you get what you want yet again. This cause came before the court on October 2nd, 2024 on the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial, e-filed 9/27/2024. The motion, the court, having reviewed the motion, having reviewed the court file, having considered the arguments offered by counsel for state, and having considered the arguments offered by counsel for defendant, finds as follows. A, the court provided an or tennis ruling on October 3rd, 2024 regarding defendant appearing in civilian clothing for trial and defendant's access to cosmetics and hairstyling throughout the trial. B, the court reserved ruling on defendant appearing before the jury free from physical restraints. C, in deciding whether to physically restrain a defendant and what method to use, the court must balance its obligation to maintain courtroom safety against the risk, quote, that the security measures may impair the defendant's presumption of innocence. See Diaz v. States. D, a court may order physical restraints only if it is found to be necessary to maintain the security of the courtroom. Before ordering a defendant shackled at trial, the trial court must make a case-specific and individualized assessment that considers 1. The defendant's criminal history and the nature of the pending charges, with special attention to whether either involved violent acts. 2. Whether the defendant has disrupted criminal proceedings in the past. And 3. Whether the defendant has engaged in any threatening behavior. See Carlisle v. State. E. There was no evidence that defendant has any criminal history. I'm sorry, what was that? Yes, she does have a criminal history. A violent criminal history. We've already done this before. Judge Kranick, what are we doing right now? We literally had this argument already. There was no evidence? If you forgot, I'll remind you.
What is your position as the head of security regarding her request to be free from shackles?
I do not believe she should be free of shackles.
Oh. And why is it that you have come to that conclusion?
Based on her current charge of second-degree murder, she also has previous domestic arrest for battery by strangulation. She has 3 separate incidents at the jail for non-compliance, where she was told to attend her court hearings, or scheduled court hearings, and she refused to do so. And then even when the corrections officers told her she could be charged with contempt of court, she still refused to attend those hearings. Those kind of, when you combine all that, to me it shows a propensity for violence and not wanting to follow lawful commands and orders of law enforcement.
First off, in your, in quotes, research that you've done on me, the domestic violence case that I was charged with, the felony with strangulation, was dropped. don't know if you were aware of that in your research. Yes, so I was never charged with that.
Hands behind your back.
For what?
For battery domestic?
Me?
Both of you. You two hitting each other. Doesn't go down like that. All right?
Is this for real?
This is for real.
Why?
I already explained to you. Chest on flag.
Why am I in trouble?
Spread
though?
your feet. Spread your feet apart.
Why am I in trouble though?
Because of
Why
the
am
marks
I in
he has
trouble?
all on his neck and the inconsistencies
That's
of
me
the story.
fighting back. I can't.
Okay, step back a little bit.
Why? Because I fucking fought back?
No, because everybody that goes in my car gets checked. No matter who you are.
No. I mean, like, seriously, like, I literally just started my job a week ago.
So the domestic violence, the original, was dropped. I was never charged with that.
It was dropped. You were charged and arrested. I don't know why the state dropped it. It could be because both parties, based on the report that I read, did not want to cooperate, so they probably didn't have information to go forward with the charges. That does not mean that you didn't commit the act. It just meant the state felt that they didn't have a case that they could win.
What is your definition of probably did not cooperate? Was it a fact or you're just guessing? Both of the charges were dropped for Mr. Torres and for myself was because we did cooperate and there was not enough information. Forgive me because I don't know what I'm doing. I'm trying to provide my information for what it is that I'm being accused of. I don't know if I'm doing it the wrong way apparently, so I don't know I don't know the protocol for this. I'm just trying to answer my accusations.
But now we forgot about that. Okay. And I let it play a little longer for a reason, because I wanted you to see that emotional switch up. We just saw her on the stand last week with all of this age regression voice. I'm so soft. I'm so innocent. I'm so this. I'm so that. As soon as an accusation comes she doesn't like, that voice drops, that real attitude comes out, that mask dips. That's who Mr. J has to pull out on that stand. That is his one job, to show the jury exactly who she actually is. The person who has to deflect, deflect, deflect. She wasn't even paying attention to the fact that she didn't have to defend herself there. This wasn't an accusation, as she kept saying. It was a fact. They were reading from your criminal history. Which brings us back to this. Judge Kranick, what do you mean she does not have a criminal history? And I think strangulation is a special and unique form of violence that, one, does not require a weapon. So it's not like she needs access to a weapon to use her go-to move, and ignoring the non-compliance in the courtroom. Also, you said that she hasn't been disruptive.
That's a lie! That's a lie!
I also think that's a lie, because she even wrote in her letter when she was upset that you made her go pro se that she was dragged out of the courtroom by her uniform while she was still trying to speak. Said order being ordered and me being pulled by my uniform to exit your courtroom while still trying to speak. She was pulled from the courtroom by her uniform. I knew it. I said I wish that they filmed this because I wanted to see this. I thought it would be delicious, and no. It absolutely would have been delicious. She was pulled by her uniform out of the courtroom while still trying to speak. So I don't know what you consider to be a disruption or not, but that is a pretty high bar if that was not disruptive. But maybe it isn't, you know. Truth is, the cameras weren't there, so you can downplay it, and then we can just ignore more things for her to get further special treatment. But whatever. She can't say they didn't try to help her. They ignored so many things that they do not ignore for other inmates just because she's annoying. Truly, that's it. She only has publicity, global publicity, is because she is such an unbelievably annoying person, on top of being cruel, evil, and spiteful, and a killer. Aside from that, there's no other reason for her to get any of this special treatment. The details of her case are not unique. I mean, they are unique circumstances. They are not uncommon circumstances. They are not hard to comprehend circumstances from a legal perspective. This case could have been done and over with within 60 days. But all of this is happening solely and completely because of her behavior. And we keep rewarding her because of it. Why would she stop? Why should she stop? She's getting everything she wants. Ultimately, she's going to dig herself her own grave, but she's getting a lot of good things before she gets there. F. Defendant is charged by way of an information filed 3/23/2020 with a single count of second-degree murder. G. There was no evidence that defendant has disrupted criminal proceedings in the past or been a contemptuous defendant during court proceedings. See DeFore v. State. We just covered this. Yeah, she absolutely did. But I think he's allowed or is saying this because the state didn't really fight back. The state just said, we've already covered this, which we have, and that the judge has already decided on this, which he has. But in that moment at that hearing, they did not present or reiterate the evidence that was already given or make an argument against it. So he is using that hearing specifically to make this ruling of, well, even though in prior rulings we brought up her criminal history and all this and all that, you didn't do it in this hearing, so I guess I don't remember anything from the past and I'll let it slide. H. There was no evidence that defendant has engaged in any threatening behavior. Orders and adjudges as follow. The motion is hereby granted. Defendant's shackles and handcuffs be removed during trial proceedings. Done and ordered in chambers at Orlando, Orange County, Florida, this 3rd day of October 2024. Michael Kranick. Kudos, good for you. You got what you wanted. None of that will help you be found innocent, but I'm glad you got what you wanted. All right. Defendant's motion in limine. The defendant, by and through the undersigned counsel and under sections and Florida statutes, request this honorable court to exclude certain evidence at the trial of this case, specifically redacting portions of the 2-hour video interrogation at the Orange County Sheriff's Office and as grounds alleges as follows. 1. The defendant, Sarah Boone, is charged by way of information with a single count of second-degree murder. The offense allegedly occurred on February 23, 2024 in Orange County, Florida. 2. During homicide investigation, the defendant was asked to come to the Orange County Sheriff's Office. The defendant arrived on February 25, 2024 and was escorted into an interrogation room. A custodial interrogation of the defendant then ensued. 3. The approximate 2-hour interrogation was recorded by audio and video. During the interrogation, the 2 homicide detectives questioned the defendant at length concerning the facts and circumstances surrounding George Torres's death. 4. At such time, statements were made by the defendant and the 2 detectives. Some of the statements made by the parties should be excluded and redacted from the video mentioned above. 5. From the transcript of the interrogation video titled Transcript of Taped Interview of Sarah Boone conducted by Detective Chelsea Copesill, case number 201794. See, now this is what you needed to do the first time. There was no way you were ever getting this whole thing thrown out. No way. So even wasting the court's time is just, it's not a good look for you. But I get it. You said in your mind you have to do it, so you tried. This is what you needed to do from the start. You needed to provide sections. I want from this timestamp to this timestamp eliminated. I want from this to this eliminated. If he had done this first, Kranick would not have watched the entire interrogation video. He would have only looked at these sections put in the motions and then rule whether they're relevant to come into the case or not. But no, because he put all of his eggs in one basket under this Miranda question, Kranick got to see the entire thing and now comes off salty as I don't know what. And not really salty, but more like completely over it. Like, I got an understanding, a feeling of who you are, but then I saw it and then I'm like, okay, that's exactly who you are. Cool. Funny enough, I think she thinks that if she is convicted, he will give her the lowest 22 and a half years. I don't see that whatsoever. I think she will get life after all the antics, the court resources, the at this point over $100,000 in Florida taxpayer dollars, the lack of remorse, the lies, the pointing the fingers, slandering everyone else, and still claiming to be the real victim when all the evidence shows you as the primary aggressor. All of that will be taken into account. And honestly, I can't wait. Well, not can't wait, but I will be watching the victim impact statements at the very end during sentencing, where everyone who has been affected by her gets to come forward if they would like to and tell her exactly what she needs to hear. But I can't wait for what Kranick is going to say when he is finally allowed to say whatever he wants right before handing down that sentence. So let's see what they want to exclude. First section of evidence to be excluded. 6. The following dialogue from pages 69 through 71, beginning on line 6 of page 69. Detective Scott Lowen: hold on. You had 2 different neighbors that lived directly next to you. You asked to use the restroom and they told you no and turned you away. You had to go, Sarah Boone. Oh, Detective Scott Lowen, across the way to somebody else. Sarah Boone. Oh, no. Okay. Kim and Eli. Eli or Kim is not a nice person. Detective Scott Lowen. Okay. Sarah Boone. She's just automatically not nice. Even after me and went over there and introduced ourselves, she's just not a nice person. Detective Scott Lowen. You. Then why would you think she would let you use her restroom? Sarah Boone. Because Eli was in there. Eli comes over and talks with us sometimes, which I think pisses Kim off. Detective Scott Lowen. Okay. Sarah Boone. Because he come over and talk to us. The 2 of them, they're like super standoffish all the time. My neighbors down the street, down the way, their toilet was broken. They had stuff in the bathroom. So then their Detective Lowen. Bathrooms. Sarah Boone. Like, go over there and try over there. Detective Scott Lowen. There's 2 bathrooms. So both their bathrooms. Sarah Boone. I wouldn't let nobody go upstairs and use my personal bathroom. Sarah Boone. That's what the downstairs one is for. Detective Scott Lowen. Or somebody you knew. Sarah Boone. They're in the process of doing all this stuff in the kitchen. Detective Scott Lowen. Okay. Sarah Boone. And there's stuff in the bathroom and the toilet doesn't work. Just move across the way. No problem. Sarah Boone. And of course they let me in. Them and them, they're together. They're part. They're families. That's what you really want to know, and I hope it doesn't get them in trouble, but he is over here illegally. I tried to hold off as long as I could, but this is where I absolutely lost my mind during the interrogation. This was completely uncalled for. It just shows how cruel, classless, disgusting, racist she really is. Straight out the gate. These people, they're just not nice people. Even after I brought my son as a prop to go over there, they still didn't like me. They're not nice people. And you notice her value judgment is she's not a nice person because she didn't immediately like me and didn't want to talk to me or whatever. And then has the nerve to go over there to ask to use their bathroom. That is so weird. I don't know if this is common, but I have never had anyone come up to any place I've lived and said, "Can I use your bathroom?" One, that takes courage just to ask. You don't know what people's bathrooms look like, but you said, "I don't care." You are a human and you enter the door. "Can I use yo shit?" And then Scott's like, "Well, why would you go over there?" And she says, "Because Eli's over there and he comes and he talks to us sometimes." And to reward the person who actually was nice to you and came and talked to you when Kim wanted nothing to do with you, rightly so, you decide to just out someone's status because you're mad that they spoke to the police. I really hope that family is safe wherever they are, but if she was responsible for having them deported, life. I don't care. Get life in prison. Another reason I feel no sympathy for what you have coming to you is because of shit you did like this. as if that had anything to do with anything. You only did it because you wanted to say, more people are worse than me, so please let me go. Look, someone's breaking the law over there. Look, he broke the law when he did this to me. Look, his family is going to kill me in this. Look, it's everyone else but me. And since everyone else is bad, I must be the only good one. Thank you very much. I will leave now. Mind-blowing. Yeah, they absolutely need to get this one suppressed. I'm not mad at this at all. I'm not mad they want this excluded. It needs to be, because just wow. And then again, they're not transcribing these things correctly. Are you not hearing? She didn't say, that's what you really want to know, and I hope it doesn't get them in trouble. She said, and nonetheless, if you really want to know, and I hope that doesn't get them in trouble, but he's over here illegally. He's trying to get his green card or whatever.
Somebody you knew.
They're in the process of doing all this stuff in the kitchen, and there's stuff in the bathroom, and the toilet doesn't work. Just walk across the way, no problem. And of course they let me in. Them and them, they're together. They're families. And nonetheless, if you really want to know, and I hope it doesn't get them in trouble, but he is over here illegally. So he's trying to work on getting his green card.
What does that got to do with you using the restroom?
They didn't want to be involved.
Should I use yours? You gotta use yours.
No, I was asking last night because,
Drops that for absolutely no reason whatsoever. And normally I wouldn't have even brought this up, but it's in a legal document, so it's everywhere now. I really, really hope that everything worked out for them. But if it didn't, wow. Whew. But it truly shows the type of person that she is. What is she going to do when the fingers get pointed at her? She always said 3-point back. She pointed all 10 of her fingers in different directions and said they are all guilty. They are all the reason that I zipped him in there and let him die. All of them are the reason, not me. So he's trying to work on getting his green card. Detective Scott Lowen, what does that got to do with you using the restroom? Sarah Boone, they didn't want to be involved. Detective Chelsea Colpsell, what's the address? That also isn't transcribed correctly. Chelsea didn't say, what's the address? Because Scott said, what does that have to do with you using the restroom? Sarah said, they didn't want to be involved. We'll come back to that. And then Chelsea said some variation of, you have to use the restroom. Does someone have to use the restroom? Basically checking in to see if Sarah needs a break or not. Not, what's the address? Address to what? I need to know who was doing this, because I don't know. Just double check before you put it into a legal document. You know what? I bet they just used closed captions and just ran with it. Didn't even double check it. Just said close enough. And now circling back to, they didn't want to be involved. Meaning you knew this family was weary of people like you, and they didn't want to interact with you because they didn't want to get involved in any of your shenanigans, because one, you always have the police hovering around you, and two, you know their legal status and why he would not want them involved, which is just ludicrous to bring that up. Linda also can't believe that you did what you did, that you said what you said, because that makes no sense. So they didn't want to be involved because they didn't want people like you in their business. Why? Because you do shit like this. When the chips are down, when people look at you sideways, you just drop someone's life-changing secret or private information for your own personal gain out of nowhere. You could have just left them alone and said nothing, but now you bothered them. They turned you away. They talked to the police. They need to be punished. And that's how you know it's intentional, when she really goes, comma, and I hope this doesn't get them in trouble, meaning I know this will get them in trouble. How do we know she does shit like this? Because she did that during the June 18th, 2019 arrest, where she called the police twice that day. In the morning, she called it for credit card fraud because he took her credit card. And then she just happened to let it slip out that he's on a pretrial release condition, that it's a no contact order. He's not supposed to be there. She just let that slip out. And the police were like, oh, okay. Because they didn't ask her about that. And then she called the police on him again at 1 p.m., just a few hours later, and then threw a whole fit for why he shouldn't have gotten arrested, even though she's the one who called them there, and she's the one who just so happened to let that secret out, let that information slip out to the people she knows will have to get these people in trouble. This is what she does. Just, oops, just slipped out, sorry. And then wants to act a fool like, oh, I didn't do that. I had no idea that could happen. Wow, who would have thunk? Sarah stated she did not invite him to her residence, but did not deny him access in. While Sarah was upstairs with a friend, Sarah stated George took a credit card of hers and left the residence. During the time that George and Sarah have been together, George has used her credit card on multiple occasions, and Sarah has allowed him to. Sarah uttered to me the fact that George was on pretrial release conditions for battery. When I questioned her about what the conditions included, she told me he was not to have any form of contact with her while the battery case was active. I inquired with her about her letting George contact her and be at her residence. At this point, Sarah became uncooperative with my investigation because she did not want George to be arrested.
One of the Hispanic males had tattoos all over him, no shirt, gray pants.
Yeah, I have to. He's here.
Other one, tattoos.
Yeah, you can stay right here. You can stay right here. He doesn't know that you call. He doesn't know how to
Another
know
black male, no prescription, hard QA, three white females, requesting an area check. What?
When do you have to? So we left earlier. We respected your wish earlier. Yeah, we respected your wish earlier, okay? But he's here.
Hey, but I'm literally begging you, don't.
Yeah, but you know he's gonna have to.
George! I'll do whatever I can!
Okay. Alright.
George!
What's your name again? I just said to stop. That's all I want you. There you go. Go call Papa Mom.
Babe, I had no idea.
Jesus Christ.
Babe!
Stop screaming at him. No. Go back inside. Go back inside. Go back inside. Jesus.
Do you need Jesus right now?
I don't need Jesus. Go inside. Go inside.
This is what she does. She does this to anyone. She did this to George. She does this to strangers who want nothing to do with her. But she knows that she can weaponize the information she has, so she does without thinking twice. And I know if she found out that something bad did happen to them, she would have thrown this whole big fit of, if they said, well, you know what, now we have to pause this interview because you told us of another crime, so we're going to go get them. So thank you. She would have, if that was in her dream ideal situation, she would have been like, oh no, don't do that. I don't want them to get in trouble. I had no idea. No. None of her behaviors are original at this point. It's just the same tactics she uses against anyone or everyone because they've worked the best for her in the past. And you can see instances like this. Because she kept getting George arrested and kept getting her way, she thought that those tactics were actually successful. They were successful in getting the action done, but not in being believed. And now, when you are in a trial about being believed, being credible, all of these tactics are going to fall flat and bite you in the ass. Detective Scott Lowen. No. I was asking last night because, we had several different people, Sarah Boone, assuming Detective Scott Lowen, stay in the neighborhood, come up. Sarah Boone. Eli and Kim, Detective Scott Lowen, saying that she was drunk on a regular basis. Sarah Boone. Eli and Kim. Okay. Did you ask Benny next door? Sarah Boone. Those are the ones, I think this is supposed to be Scott. Those are the ones next door that she asked to use the restroom and they didn't They swapped this. Okay. Sarah Boone. Those are the ones next door that she asked to use the restroom and they dad no. Defendant Scott Lowen. No, she said no. Y'all. How did y'all flip that? It should be Detective Scott Lowen. Those are the ones next door that she asked to use the restroom and they did no. They said no. Sarah Boone. No, she said no. Detective Chelsea Copsell. Okay. Sarah Boone. Like I said, she's not a nice person. 7. The exclusion of the said evidence is required due to a lack of relevance under Section Florida statutes. In addition, the evidence is improper character evidence under Section Florida statutes. It definitely is character evidence. It shows exactly who she is and how she works. But yeah, I think this will get suppressed. I have no issues with that. I hope they do. And honestly, I don't think the state would have played this part anyway. But yeah, I don't think they have an issue with that. The second section of evidence to be excluded. 8. Page 53, line 8, Detective KC. Well, he's dead as a result of your actions. 9. Line 13, Detective KC. He's dead as a result of your actions. 10. Line 14, SB. I understand that. 11. Page 55, line 24, Detective SL. I have one last question. You realize you're the person that killed him, right? 12. Page 56, line 1, SB. I thought about that. 13. Page 92, line 15, Detective SL. Well, intention or not, George is dead. You act like when you say unintentionally, that absolves you from everything. She sure did think that. I completely understand why they would want to get rid of this. That makes 100% sense. I think Cranick would suppress this. I would still argue to keep it in because why not? She basically just admits that she knows she is the cause of his death, and that is all they have to prove for second-degree murder. They do not have to prove motive. They just have to prove that she did it and that she understands she did it. Or not even that she understands she did it, but she admitted that she did.
What are your questions?
I have one last question. You realize you're the person that killed him, right?
I thought about that.
Okay, you left him in a bag when he's begging you, saying, I can't breathe, let me out, and you said, fuck you. And you got up off the couch and went upstairs and left him in that bag.
Not intentionally.
Again,
I would never do that to George.
you did.
Not intentionally.
14. The above evidence is improper opinion testimony by law enforcement officer. Law enforcement cannot express opinions on the law or the ultimate issue of fact for the jury. See Ode v. State. Hey, case law. That's new. 15. In addition, said statements assume the truth of contested facts and encourage the jury to find the defendant guilty as charged because a law enforcement officer said so. If this opinion evidence is admitted, the jury may assume the validity of the law enforcement officer's opinion because it was allowed in evidence and rely on the opinion in finding the defendant guilty. The issue of causation is exclusively the jury's job. The opinion evidence invades the providence of the jury's fact-finding mission. 16. The exclusion of any or all of the evidence described above is required as the value of such evidence is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading the jury, and would serve only to inflame the jury. See Smith v. State. Wherefore, the defendant requests this court to enter an order excluding the above statements from the videotape interrogation in this manner. Respectfully submitted, James Owens. And I'll say again, this is what he should have done from the start. You could have put even more of it. If you didn't try to suppress the whole thing, you could have brought a whole bunch of sections in to where Cranick would go look at those specific sections and he wouldn't think that your client is just a lying POS. At least this looked better than pretty much any of the other things they've done. And there was case law. Not a lot, but there was some. I'll take it. I definitely think the part about the neighbor will get suppressed. Iffy up in the air about how the detective statements where she just admitted that she realized she killed him, how they're going to go. But we'll see. State's response to defendant's motion in limine regarding defendant's February 25th, 2020 statement. Comes now the state of Florida by and through the undersigned assistant state attorney and alleges and states as follows. 1. The state does not object to defendant's request regarding pages 69 through 71. And that was her snitching on her neighbor. So we're glad everyone agrees, get rid of it. 2. The state does not object to the defendant's request regarding page 53, 55, 56, and 92. Bush v. State. The statements are designed to elicit responses from the defendant, and they did. They are not statements regarding the law or an ultimate issue of fact for the jury. At issue is whether the death was an accident, as she continuously insists in this case, even as recently as October 1st, 2024, ... not whether she caused his death. I love me a shady ellipses. But yeah, for this, the state is objecting. And the reasoning is the defense is saying that the cops are making statements that are assuming the fact that she killed him. And the defense's argument is that the officers are not allowed to suggest or imply that that is what happened and make a legal conclusion, which then can be taken into account by the jury. What the state is arguing is that those statements are made to elicit responses, not to come to a conclusion or to assert a conclusion, but to get a response from her that either confirms or denies it, and then they did get a response from that. But that is not them drawing the conclusion on whether or not she killed them. They're drawing the conclusion and trying to elicit a response on whether it was an accident or intentional. Everyone knows she caused his death. We are just debating how, why, and is it justified. 3. The defendant can request the court to read Florida Criminal Jury Instruction 2.8, recorded interview effect of law enforcement statements on the defendant. It reads as follows. You are about to watch a recorded interview that contains opinions and statements by Detective Copsell and Lowen to Sarah Boone. These opinions and statements are pertinent only to explain the reactions and responses they elicit. You are not to consider these opinions and statements by the police officer as true, but only to establish the context of Sarah Boone's reactions and responses. And I think that's a fair and strong jury instruction. If, for anyone who doesn't know, jury instructions are things the judge gives to the jury right before they go back to deliberation, and it's basically the rules and guidelines that they have to follow when coming to their decision. So the whole time the trial is going on, the lawyers are also fighting for jury instructions to be more in favor for their cause, because cases can be won and lost off of jury instructions alone. This is a hypothetical one. It's not actually one, but let's say hypothetically you got a jury instruction that said you cannot use anything you saw her say or do on a video tape as evidence. You can't use anything that she said on video as evidence. That would never happen, but let's just say that's the jury instruction. That means they could only use the evidence outside of those videotapes, even if they know what's on the videotapes and they believe what's on the videotapes, because that jury instruction says you cannot use that to come to your decision. You have to kind of mentally exclude that. And if you're coming to your justification, it can't be because of what was said on those videotapes. And you would have to anchor it into the other facts of the case. Like I said, that's a hypothetical, highly, extremely, almost impossibly unlikely. But jury instructions like these are good because it's saying you just heard something very damaging in that video. You are not to consider those words. I'm recontextualizing them for you. What they said was opinion made to elicit a response, not to assert a fact. So the fact that those officers said those words does not mean that that is the conclusion you should draw from it, or that that is the necessary conclusion that the officers had themselves at that moment. They just said those statements. The purpose of those statements was to elicit responses and reactions, and they did. You can now look at the responses and the reactions and take from them whatever you like to take from them, but do not go off of what the detective said. That was very long-winded, but I think we got the point. I certify that a copy, William J. Robert. I think that was a solid response by the state. I agree with their arguments. I think Kranick is going to strike both of them or suppress both of them. Because why risk it, honestly? I think Kranick has sided with Sarah on the needless battles that don't need to be fought. This is not one of those you need to fight it, because it's not like what was said in those two sections are the most damaging aspects of that interrogation. If they were trying to throw out all of these other instances where she incriminated herself and blatantly lied and goes against what she's about to say on the stand, then it would make more sense to argue back and forth on that, and Kranick might not allow all of those to be suppressed. But something like this that does not hinge on the facts and is more weighted in opinion, I'm just going to say 100% he's going to deny these. I don't know yet, but I'm just going to assume. However, the state's arguments are good for the record, regardless. Moving on. State's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force. Now, this is basically resubmitting the motion that got denied earlier, because the only reason it was denied and the only arguments the defense had was Wagner, all of these cases they cited that completely destroyed our argument, they all mentioned that you could only strike this during trial or at trial, not during the pre-trial conference, but during the trial. And so now we're at a different stage. They're resubmitting it. They're adding new details and getting more specific. So I am more inclined to believe that this will be granted this time, but who knows? This just means it's going to be another hearing. Fun. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. Introduction. 1. The defendant has filed a notice and an amended notice of her intent to rely on battered spouse syndrome evidence in this case. 2. Battered spouse syndrome is not actually a defense to a crime. The introduction of battered spouse syndrome evidence to support a self-defense theory is not for the purpose of justifying a defendant's misperception of reality or to explain why an unreasonable belief was nonetheless justifiable due to her condition. Rather, the Florida Supreme Court has sanctioned the use of battered spouse syndrome to show why the defendant's actions were reasonable, to show, in spite of a reasonable perception of danger from the battering spouse, the battered defendant would remain in the home with her batterer, where she may resort to the exertion of force against him to prevent imminent death or great bodily harm. Now, I know that can sound a little confusing because it kind of sounds like the same thing twice, but I'll try to break it down as much as I can, and I could be wrong, but I'm going to give my best explanation of it. So, first of all, battered spouse syndrome is not a defense. There's no defense that says battered spouse syndrome specifically. The defense is self-defense. I did this to defend myself. It's self-defense by way of battered spouse syndrome. So, what type of self-defense you're trying to, that's the layer that comes in. The defense, self-defense, reasoning, justification, subpart, addendum, etc., battered spouse syndrome. Moreover, battered spouse syndrome is not saying because you have this, it justifies the actions you took, as in it doesn't justify you killing them, you zipping them up in the suitcase and doing it, you stabbing them a million times, you shooting them a million times, whatever may be the case. It doesn't justify that. It justifies the mental state of why you would stay in a situation where that kind of violence can occur. Why would you stay in a situation if you've been beaten so many times, if you are in this constant fear of danger, that you cannot leave, that you perceive everything as a threat because of the past abuse that you've experienced? If all of that is true, why are you in that house? Why are you there? If you are in imminent fear for your life, why are you there? Battered spouse syndrome is there to explain that. To explain that even though it doesn't seem to make sense why someone who's been in such an abusive relationship would stay with their abuser in the same proximity, not just relationship-wise, but live with them, knowing that they are in constant fear of danger. Battered spouse syndrome is there to explain that, saying because of the psychological and physical traumas that people can experience in relationships like these, they feel they do not have a way out. Sometimes it's literal, they do not have a way out, where maybe the abuser is a police officer or someone in power, where there's nowhere they can turn, there's nowhere they can ask for help. Odds are, if they are in that authority figure, they've engaged in isolation techniques too. I'd be shocked if they didn't, where they are separated even further from support systems to where there is no way for them to get out. That is your mentality of, why did you stay there? You had to. That was the abuse that you were under. Even if you literally, by definition, had the opportunity to flee and leave and run away and call the police and ask for help, which is the expectation when you feel like you are under attack and in imminent fear of your life, for your life. This is trying to say there's a reason why that didn't happen. Not saying that her shooting him so many times is justified through that. It is her being in that situation that could end and result in her shooting him in order to defend herself is justifiable because of blank. It's basically meant to tell them you can't blame the victim for being in an abusive relationship and being in that home in that moment in time for that to happen. It is not there to justify saying, because of this abuse, because of this warped perception of reality, because they thought they were in fear of danger, because all of this and all of that, it is justified to take those actions. You have to split it apart and judge them separately. One, you can't judge them for being in that situation. That's where battered spouse syndrome comes in, to justify and explain why mentally they put themselves there instead of leaving, versus you have to look at the self-defensive measure itself. Was it reasonable? Is this self-defense? And that's why the state is saying she has to testify that she was in imminent fear of danger in order to make this type of self-defense make sense. To kill someone, you have to have justification for that. You have to show that you were in imminent fear of your life. You were taking self-defensive measures that resulted in you taking those actions. And even in cases where the spouse kills their abuser while they're asleep, normally that is following an action that happened, that I was in fear for my life. It keeps happening. I cannot escape. I had to wait until they were vulnerable, and then I did what I did. She put him in the vulnerable position. Not the same. Because by all accounts, there was nothing for her to defend herself against. She needs to get on the stand and prove through her own testimony that yes, he did attack me that day. I was defending myself. I feared for my life. He did X, he did Y, he did Z. You have to get up there and say that before you can bring in, now here's all this evidence, here's all this history of violence he's had with me, here's all of this, here's all of that. She wants to open out the gate with that, saying he is a wife beater, so it's okay that she did this to him. She wants to say that on day one. They are saying, nope, you need to go through trial until we get to you. And you can say your piece. Then after that, you can bring in all this BS. Or BSS for battered spouse syndrome. Moving on. Facts. 3. The defendant has presented several accounts of what happened on February 23rd, 2020. Oh! She made a 911 call at approximately 1 p.m. on February 24th, 2020. She spoke to a patrol deputy on body-worn camera shortly thereafter, provided a statement to detectives a few hours later on February 24th, 2020, and provided a second statement to detectives on February 25th, 2020. 4. The defendant retained Dr. Julie Harper as one of her battered spouse syndrome experts in 2020. Over the course of the next several years, Dr. Harper interviewed the defendant about the events of February 23, 2020, multiple times. See Exhibit A at hearing on this motion will be Dr. Harper's deposition, which was taken October 1st, 2024. The state would direct the court to see pages 35, 37 through 39, 41 through 42, 44, 47 through 50, 52, 54 through 56, 66 through 67, 88 through 81, and 95 of Dr. Harper's deposition for the defendant's statements about February 23, 2020. 5. The state retained Dr. Tanya Werner as its battered spouse syndrome expert. Dr. Werner evaluated the defendant on October 2, 2024, and Dr. Werner was deposed on October 4, 2024. Exhibit B at the hearing on this motion will be Dr. Werner's deposition. The state would direct the court to see pages 75 through 79 of Dr. Werner's deposition for the defendant's statements about February 23, 2020. 6. The state is not asking the court to make any credibility determinations about the defendant's statements to the doctors. That would be for the jury to do, in the full context of a cross-examination with the defendant's statements to law enforcement. Mr. J is chomping at the bit. He wants at her. That cross-examination is going to be fiery. I would take days. I would be shocked if it takes less than a full day to cross-examine her with all the mess they have against her and how long she's going to draw everything out and how combative she's going to be. But he just said, Judge, I don't even need you to see whether it's true or not. I'm not asking you that. Don't worry. I'll take care of that when I roast her ass on that stand. I got you. But what I need you to see is that the script is flipped. It doesn't make sense. She's claiming accident. She can't claim accident with this new defense, or she can't claim this new defense while claiming accident. And I'm going to prove to you that she is claiming accident, even though she says that she's not. That's where we are now. 7. What the state is asserting is that as a matter of law, what the defendant told the doctors does not entitle her to a self-defense instruction, nor does it entitle her to introduce evidence of prior instances of violence, reputation evidence of the decedent's violence, or battered spouse syndrome to help the jury understand why what she did was objectively reasonable. 8. The defendant told the doctors that because of past violence between her and the defendant, she had a generalized fear every day that the decedent would cause her serious bodily harm or kill her. You were afraid every day. That's why you bailed him out of jail. That's why you invited him over. That's why you physically drove to go get him, to bring him back to your place. Not you going to his place. Bringing him back to your place, because you feared every single day he was going to physically harm you and end your life. It doesn't track, does not track. You have to be in the situation where you have no power to leave and can't get away from them. You have shown that you can kick him out anytime you want. You can leave anytime you want. You can have him arrested anytime you want, and you can bring him back anytime you want. So, good luck trying to prove that. 9. However, on this particular day, the decedent did not take an overt action, even in the slightest, that made her believe he would cause her serious bodily harm or death. 10. According to the defendant, when she and the decedent woke up, the decedent wanted to drink alcohol. She did not. So in order to distract the decedent, she suggested that they instead clean the defendant's townhouse. Okay, so we're backtracking and we don't drink anymore. Or we do drink, but it's his fault. That's it. She denied it up front. I'm not drunk, we're not drunk, we don't drink, I'm not an alcoholic. Then it was, oh yeah, I was drunk and that's why this happened. Now it's, I was drunk, but only because he made me get drunk. He makes me get drunk and he makes me hurt him when I get drunk. It's his fault. Still, no personal accountability for anything. Every single choice every single negative choice is caused by someone else. And anything positive that happens to anyone or in the vicinity is because she did it. Nah. Train does not believe it either. None of us do. But even to this day, she is going to tell those lies that it's everyone else but me, which they did. 11. At the conclusion of the cleaning, the decedent still wished to consume alcohol, so the two of them began consuming alcohol. The defendant did not want to consume alcohol, but she did so to placate the decedent. All right, Drunky the Bear. Nobody is going to believe that. That was literally your nickname. They called you Drunky the Bear.
Her nickname's Drunky the Bear.
Now you want us to believe that you only drank to placate him? No, that is so desperate. You've had 4.5 years and you still couldn't come up with a better lie? You still couldn't take any responsibility? I only drank to placate him. Not that you wanted to drink. It'd be better if you were like, I was under such an abusive relationship that I wanted to drink. I wanted to be numb constantly because I couldn't stand being in the relationship I was in. It was so controlling, domineering, dangerous, yada, yada, yada. But no, I only drank because he forced me to drink. Constantly, nonstop. She hasn't mentioned anything about cigarettes. That's almost in all of her other stories of, we just smoked cigarettes on the back porch, we were just cigaretting out, we were just cigaretting in the morning, cigaretting in the evening, da-da-da, but now it's just drinking. I'm only drinking to placate him. When everyone else says y'all were thrashed 24/7, particularly you, Miss Paulson.
Her main problem is she can't stop.
Okay.
I mean, she can't go out and have a glass of wine with dinner.
Right.
That's not a thing she can do, because once she starts drinking, she will continue drinking basically until she out.
Did they both drink a lot?
Yes,
Yes. Okay.
in excess.
What?
In excess. They didn't drink to drink. They drank to sunrise to sunset, all the time in between.
Okay.
They almost always seem either like tired or like tweaked out.
Tweaked out?
Yeah.
Okay.
I do know that I have seen both of them intoxicated as early as 9 o'clock in the morning, and I mean staggering, falling down intoxicated. Both of them. Sarah was actually wandering around the property very drunk, barefoot, not properly dressed. I'll say it like that.
How did she sound?
She sounded like crazy, like she always did. Like
the way they presented themselves, you know, they were always drunk, like I was saying before, like always, like sun up to sun down type, like all the time. And it was like, I guess people just didn't really want to interact. Yeah, because it's like
12. The alcohol that they consumed was a Chardonnay bottle by Woodbridge. 13. In order to prevent the decedent from becoming sad or upset, she kept him diverted by smoking cigarettes with him, drinking, enjoying each other's company, perhaps using the dartboard on her porch, and doing arts and crafts and puzzles. Whoops, I was wrong. There it is. There's the cigarettes. Like I say, I know what's coming, but I don't always know what's coming. And the dartboard's new. Where'd the dartboard come from? You've told this story a million different times, and this is the first time I have ever heard you say dartboard. You keep adding details. That is not the sign of a truthful story if details are continually being added. 4.5 years later, and we're just now talking about this dartboard? Still arts and crafts, puzzles, enjoying each other's company? A mess. And it's all these like maybes. Maybe we were playing darts. Maybe we were doing this. Maybe we were doing that. I didn't want him to be sad, but you wanted him to suffer. You wanted him to squirm. You wanted him to die, but now you want us to believe you didn't want him to be sad? Okay. 14. Although it apparently would upset the decedent, the defendant suggested he call his daughter, who did not like talking to him when he was drinking. I'm going to pass you a nice, smooth fuck you, okay? Because you were a nightmare the last night he was alive, especially with that phone, because he tried to call his brother and you gave them 4 minutes. before you made him get off the phone because you said you wanted to talk with your brother. You wanted to use the phone to call your brother. And I got this little graphic from a video from Caricatures. I can't remember which video, but I'll put a general link to her channel in the description below. But it has a little timeline of that they were able to put together of what really happened chronologically. And here are the phone calls. So I want to take note of a few things. First of all, it looks like the first Publix receipt for the wine was at 12:17 p.m. So that must have been, oh, we cleaned the apartment. Now he wants me to drink again. So he himself went out to Publix to get the wine that I didn't want to drink. Then he brought it back and forced us to drink. Doesn't quite make sense to me. But then a few hours later at 5:39 p.m., he goes back to Publix and gets another bottle of wine. We know that they got 2 bottles and that Sarah lied to the officers and said the first bottle was from prior, you know, that it was half a bottle finished, yada, yada, yada. And she was right. It was from prior in the day, earlier on in the day, not days prior. She always loves to hide time with those kinds of words to make it very nebulous. But then it looks like from here, he tried to call his daughter at 7:24. Couldn't get her. Tried to call his other daughter. Couldn't get her at 7:25. Then at 7:30, it looks like he tried to call his brother. And he was on the phone with his brother for 4 minutes and 6 seconds. So he tried to call both of his daughters and then his brothers. It seemed like he just wanted someone to talk to. Like he wanted his family, needed to talk to his family, to hear a familiar voice, to hear something. But, you know, sometimes that just doesn't happen. But the fact that 4 minutes in and she stops that phone call with the brother. And according to the brother, it was a good phone call. They were laughing. They were laughing with his nieces and nephews.
At first I wasn't going to pick it up. Then I picked up.
Okay.
Because they were always fighting and stuff with the alcohol. And he started talking to me. He was calm, so I was like, oh, okay. So I put it on speaker. So my kids are there, like, they joke around with him, and he was joking around with them. And we're talking, and then he's talking to me about when we was kids. And then, like, a couple minutes after that, that's when I hear in the back start arguing with him. No, I have to call my brother. I have to talk to him. And he's like, no, I'm talking to my brother. It was her phone, so. And then she starts arguing and telling him that, no, tell him what you've been doing to me. You choked me, this and that. But he was calm. And he was like, okay, I gotta let you go. And then he said, I love you. And then I told him I love you. And basically, that was it.
And then here comes Sarah barging in saying, I need the phone. I need to call my brother. I need to call my brother, just because George was on the phone with his brother. Tell him what you do to me. Tell him that you beat me. Tell him that you hit me. Tell him that you that. Because she would do that all the time. She would say those things around other people, knowing he can't deny it, or else it would just blow up into this humongous other thing. She'll never admit the damage that she's caused and the things that she started, but she had no problem telling everyone who would listen that he hit her. Most victims do not feel comfortable saying in front of their abuser to other people that they are being abused by them. Abusers feel comfortable doing that all day long, because what are you going to do? What are you going to do as the victim if your abuser tells everyone you are abusing them? Absolutely nothing. You will say nothing. And from what we hear, he didn't try to defend himself that much in terms of, that's a lie, that's this, that's that. He just accepted that as the truth because in part it was true. But in other part, he knows if he did say something, it would be 10 times worse, especially when they're not in front of them. And when they got back to their house, oh, you're going to say this in front of that? You're going to do this and not that? And then you blow up again and the police get called and he goes to jail. Because it just depends on her mood, whether he gets to be free or not, pretty much. I mean, yeah, until his death, she got to decide whether he was truly free or not. And then by this timeline, we see that there was arguments afterwards. And then at 8 p.m., George tries to call both of his daughters again. And it looks like that was unsuccessful. Meanwhile, Sarah told the detectives the next day that they called his daughters. And then they called her son. She didn't mention calling her brother. She didn't call her brother according to this timeline and what I imagine the call records show. So she just said, I want to call my brother just so she can get her phone back, quote unquote. And she'll make sure it's her phone when she wants it. It's our phone when anyone else asks about it. So it's just never-ending lies of she doesn't want to talk to him when he's drunk. And I don't know if that's true or not. Maybe that was true at some point in time, but that's not always the case. Why do we know? His daughters doesn't know he was drunk. Unless you texted them saying that. How is he supposed to know? I mean, how are they supposed to know that their dad is drunk unless they pick up the phone, hear that, and then hang up the phone? From what we see, they just didn't answer because, life, who knows? And also he tried to call them twice within the hour. So a million things could happen. Unfortunately, I know it probably breaks their heart that they didn't answer those phones or that they couldn't answer at that time and that they weren't able to call back because, no one knows. So let that be a reminder to just love your loved ones extra harder every day you can, especially if you know that they're in trouble, as in going through a hard time in life, trying to make it day by day. If they are making attempts to genuinely get better, acknowledging their faults and genuinely trying, acknowledge that and make them feel loved and understood in that way. I'm not saying that he didn't. I'm just saying that in general, we should all be more cognizant of that and appreciate that so that we can save more people before they get lost in abysses of other people like them who tell them they understand when they really don't, when they really only want to be superior to them and to control them. And if they can't control them, then they'll take any control or freedom they can from them. Large tangent, but in summation, I hate that she said this about the daughters, knowing it's false. Or that he calls his brother to tell his brother that the decedent had dragged the defendant down the stairs the night before. No, I'm not done. I'm still stuck on this. She said that she told him to call his daughters and to call the brother and tell the brother that he'd been beating on her. So she's instructing him to call his brother to report himself. What? And she did this at the crime scene where she said, basically, he hasn't been around them because he chooses me over them, even though I've told him to go over there and to talk to them and this and that. We know you didn't do that.
They call me because they don't want him with me. So he's basically just not really been around his family because he chooses me over them. Even after I've encouraged him numerous times to go over there and see his family.
We know that is bull. We know she did not like how close he was with his family. There was something in the September 4th body cam footage where she let her mask slip after having a story that made no sense like 6, 7, 12 times. They kept trying to ask her, when did you get hit? When did you get hit? She couldn't explain it. She couldn't put it together because it didn't happen. But what she could put together is that he insulted her, called her bad names, and said that she wasn't a good mother. And then the true vitriol that I think started that whole instance is she said, he's always talking about his kids.
And then what happens?
He's always talking about his kids. Pardon me for saying, and a bitch, and not a mother.
In this just visceral, guttural tone, as though she can't stand that he loves his kids, that he wants to talk about his kids and wants to talk to his kids. And he called her a bad mother because I imagine she was upset that he kept talking about them, wanted to change the conversation to talking about her or something else, or even him mentioning, why are you always talking about them, something, something, something. And then he retorts, you're not a good mom. That's why you don't understand why I like talking about my kids, etc. Who knows? But out of that whole night, that was the most emotion that I saw from her. Genuine emotion where everything fell, and that's how she really felt. So I don't believe for a second, not for 1 second, that she instructed George to call them for his own good. 15. Having done these playful activities for numerous hours, there came a point where the defendant and decedent were sitting on her couch in the downstairs living room, and the decedent tagged her and said, "You're it." From past games of hide and seek, the defendant understood this to mean he wanted to play hide and seek. She begrudgingly engaged in this game, as with everything else, to placate the decedent. Wow, this is hard to read. Whew. Begrudgingly played the game. You are the one who suggested it. That's what you've been saying in the interrogation. That you were like, oh, I'm done listening to the music. Oh, we're all puzzled out. We're all art out. So do you want to play hide and seek? Sure. Tag. So we both know what we're supposed to do. That makes no sense at all. And she still hasn't connected that to this day. And maybe it's because she's just in too deep with it. But you do not play hide and seek by tagging the other person. I get it. You can say tag as in, we're not playing tag, but I'm saying you are the first one, it. But that would not make sense for someone to tag you and then expect you to hide. Normally, you do the tag, you're it. The first person who says tag is the one who gets to, more lack of a better term, flee from the other one. And the other one is the one who's either it or the one who has to count to whatever before they go seek the hider. If he tagged you, that meant you were the seeker and he was the hider. But your story is you have yourself going upstairs. So how does that make sense? That he tagged you, him saying I'm the seeker, and for you to go upstairs. I mean, that's the only way it makes sense, but who does that? Without further explanation. If he had tagged her and said, you go hide, I will seek you, which she is not saying he said, then that would make more sense. But she's saying, because he tagged me, we knew from past games of hide and seek, that means he wanted to play hide and seek. She begrudgingly played along. None of this looks good for her. She's making it sound like now that she was forced into all of these activities. She was forced to drink, forced to do the artwork, the puzzles, the hide and seek. When on the day of, everything else is reframed. She is the one who says, I had him come from outside to come in and do these things. I had him turn his music down. I had him move on to the puzzle, move on to the artwork. She is stating multiple times that she directed his course of action and he listened.
What time he was zipped up in the luggage, what time you went upstairs?
We started because we cleaned the house a little bit, did some laundry.
You started the activities around 4, you said?
Yes, around 4:30ish, and then...
You just said that it was dark when you were playing hide and seek, and I'm just curious if you remember.
But when we were outside, that's where we would start and talk about things, and then eventually I was the one that had him come inside. So we could...
About what time, do you remember what time that was, is what she's asking.
Gotcha.
Plus it started to get dark and gnats and mosquitoes.
Yeah.
So... let's go inside. I don't want to be out here anymore.
Okay.
All right, let's go. So we're doing whatever. We did it for a while because that puzzle, I don't know if they took it or they saw it. Worked on the puzzle again, finished it. Started to paint. Well, started listening to music for a little bit. Started to paint. Can we turn the music off? No problem. Start at the top, paint, whatever. Maybe... gosh, that puzzle, we worked on that for probably a good hour and a half. So 8 o'clock-ish?
Is when you went to hide upstairs originally?
No, that's when we were like painting. So then it's like, okay, well, I don't want to paint anymore. Let's just, come on. Okay, you want to play hide and seek? What he does is, okay, tag, you're it. So it's like, okay, we know. Okay, take off. That's what we did.
That story didn't make sense then. It doesn't make sense now. it's always his fault somehow. She's saying that like he is directing this when it's really her directing all of this. Let's go inside. Let's listen to music. Let's turn the music off. We know it was her who wanted the music off because she's the one who said his music, I don't like listening to his music because his music's a little rough around the edges. And so it just makes me fractious listening to it. So we know she's the one who asked him to turn the music off. She's the one. I can guarantee he is not the one who suggested working on that damn puzzle. Can guarantee that. He is an artist, so I would not be shocked that he was engaged and willingly participating in the artwork phase of this night. But the rest of it is so iffy. I believe that she probably forced him into doing the puzzle, but not that he was enthusiastic about it, nor enthusiastic about hide and seek. I don't believe that happened at all. It makes absolutely no sense based off of everything that we've heard. And she's saying that she finally got in at around 8 o'clock because she's hiding time again. Originally, she told the first officers at the scene that she started playing hide and seek around 11:30, 12:30. She said 12:30-ish. We know that was a lie because the videos happened at 11. But originally, she's saying that they started playing hide and seek at midnight or around 11.
Drinking a bottle of wine.
Putting puzzles together, doing artwork.
Doing puzzles, artwork. Okay.
Had a bottle of wine and then decided to play hide and seek. So he
What time was that? Do you remember?
I mean, I know that I was in bed probably by like what, 12:30?
Okay.
Well, I went upstairs at least and I fell asleep.
Okay.
Forgetting that he was
so
in
you
the
guys
suitcase.
were playing the hide and go seek.
Yes.
And at some point you put him in the suitcase?
No, he got in the suitcase. So he thought it would be funny to be put in the suitcase. So I was like, okay, well, I'm going to joke with you and I'll zip you up and make him, squirm a little bit, whatever it is. But then I fell asleep. I fell asleep.
Where was the suitcase?
Right where it is.
In it? Right down there?
Yes.
You zipped him in there?
Yes.
Thought he would be funny, a little
It
joke.
was. We both were laughing about it.
Okay.
And then I fell asleep.
Where did you fall asleep at?
Upstairs.
In your bedroom?
Yes.
Okay.
Totally forgetting that he was in the suitcase still.
Okay.
So we have another case of her even hiding time within that. They ask, what time did this happen? She says, I was in bed by like 12:30. Obviously, she has confirmed that this was the last thing they did that evening before she went upstairs, fell asleep, and let him there to die. So that was the last thing they did. I think she would know, or at least her lie would be a little more concrete, if they had played hide and seek for hours beforehand, which would have to be to connect to that 8 p.m. time. So there's that whole block she's completely omitting intentionally for reasons that we have started to learn. But if she went to bed at 12:30 and that was the last thing they did, they would have had to have done it within the past hour or so. Otherwise, I would be shocked to believe that she would omit the idea that they were playing hide and seek for 2 hours. I don't even know little kids who can play hide and seek for 2 hours without getting bored, especially when it's just two of y'all and it's upstairs, downstairs. I would be shocked if y'all played even more than 2 rounds of hide and seek. I don't think you played it at all. But even in this made up scenario, it does not sound like you played many rounds before leaving him in there. Your story has it tracked out as you played 2 rounds. 1 round where you hid, even though he tagged you, meaning that you should have been the seeker. And then you came down and you saw him hiding. And then you zipped him up and left him there to die. So it had to be right around 12:30. We know because of the videos that it was around 11. And corroborating with the neighbor's testimony that they heard things go quiet from 10:30 to around 11:15. And the videos were filmed at 11:12 and 11:23. With another phone call to Brian at 11:46. So we have a pretty tight timeline. She did go to sleep around 12:30, but they did not play hide and seek that long, and she did a lot of things before she went to sleep. And a lot of those things that she did happened while he was still in the suitcase. And who knows how long he was actually in there before she brought out her camera? We just know from the time she brought out her camera to the time that she called Brian over a half hour had gone by. So he was at least in there for over half an hour. And honestly, I don't know, and we're going to find this out during trial, I don't know how long he survived in there before he finally died. My hope is that he died very quickly. That is my hope. I hope that in her drunkenness, she noticed she didn't hear any movements or anything like that, and that's why she called Brian, either to gloat about it or trying to get him to come clean up her mess, because that's what she does. She calls him when she needs her mess cleaned up. Normally, her mess is her life, and this is no different when she takes one. But now, Miss Camp Counselor, who directed their whole night, begrudgingly participated in hide and seek to placate George. Like, why is she there? Honestly, why is she in that room? She doesn't seem to like him. She sees him as a burden. She doesn't want to drink with him. She doesn't want to hang out with him. It is all to placate him. And you have to convince me now that he has some power over you. You can make an argument about the physical power, maybe some psychological possessiveness. However, we know they were similar in size. He weighed less than her. Maybe he had, more muscled strength, what have you, not by a lot. So it's not like she was in fear of her life. She had no control. She likes to say that she was ragdolled. Where? I do not think he could physically lift you and throw you across the room. Unless he's like Popeye and alcohol is his spinach, then I don't see him turning into He-Man and just ragdolling you across the room. He doesn't have money, so he does not have any financial hold over you. He doesn't have access to your children or your family and support system in the way that you have access to his. Why are you there if it seems like you are miserable all the time? Except you're also the best thing that ever happened to him. It doesn't make sense. And can you imagine living in that? Every day you don't know if you are an angel in her eyes or a devil. And she'll treat you like you're both, regardless of how she actually feels inside. But that still just shows she can't come to terms with her own alcoholism and where she is with it in life when she still has to push it on someone else. It would make way more sense for her to say, I drank in order to forget about the abuse, or I drank with him because when we were drinking, that's the only time he wasn't abusive. So that's why I would drink. I mean, she's still blaming it on him, but it'd be more believable. Not this, I only drink to placate him because I don't want him to feel sad. Girl, goodbye. Goodbye. 16. She ran up to the shower after becoming cold and perhaps some misunderstanding about the rules of hide and seek. She left the shower upstairs and returned downstairs to find the decedent placing himself in a suitcase to hide. At the time of his death, the decedent was only 103 pounds and had a blood alcohol level of 0.138. Wow. So he was almost twice over the legal limit. And we don't really know for sure because alcohol metabolizes differently after you die, so it's a little skewed left or right. But it looks like he was incredibly intoxicated that night as well. So even if she let him have those two little fingers out, there's no way he could just feel around and figure things out, especially if you were pushed down a flight of stairs. You don't know what's up, what's down. Your senses are deprived, you're trapped in the dark, and you just have someone laughing at you. The only sense that works is your sense of touch, the pain from the bruises and all of the injuries you have, and your hearing. You can hear her right there. She could help you at any moment. And she doesn't. Also, who hides in the shower? If y'all are playing hide and seek and there's upstairs and downstairs, there's almost nowhere you can hide. I'm checking the bathrooms as one of the first things. The bedroom and the bathrooms. That's it. That's all you got up there. And you're in the shower, not in a closet, not anywhere believable. And Mr. J says she got cold and then came down. Is that what she told the doctors? She told the doctors she hid in the shower, but then got cold and bored or tired or upset that he didn't come find you, and then you left. It sounded like you genuinely did not understand the rules. You thought he was supposed to seek you. I guess he thought you were supposed to seek him. So y'all both just went hiding. But of course, you being you, you gave up first and then got mad and come down and you see him, I guess, hiding himself in a suitcase. None of this makes sense, right? I'm just trying to go down her mythical path of logic. And so then what? You see him starting to get in the suitcase. He can't zip it up himself. And it's not like you can just zip it up instantly. So you have to struggle there. Either you jump on top of the suitcase and zip it up really quickly while he's not looking or whatever, or he asks you or something. That never connects for me. How we get from I saw him hiding in the suitcase or about to hide in the suitcase and I zipped it up. I do not think someone will willingly let you zip them up, even if they just caught you at the last second. Which leads me to believe he wasn't conscious or was incapacitated when she zipped him up. Damn. 17. The defendant saw him doing this and decided to zip the suitcase shut while the decedent was inside. They were both laughing, and there was still no animus between them on this day. The defendant states she did not zip it completely shut. The decedent was able to poke a couple of fingertips through the gap left by the zipper. 18. And then, the decedent said he could not breathe. The decedent obviously got mad about not being able to breathe. The decedent's getting mad made the defendant get mad. This reminded her of the past violence the decedent committed against her, causing her to be unable to breathe at those times. This made her angry. The defendant shook the suitcase. She lost control and the suitcase slipped. She hit the decedent's fingertips with the wooden baseball bat that was in the room. Wow. There is so much to unpack there, but I do think we got a little more truth than we have about any of this. Still a lot of lies, but more truth. So she comes in, she sees him hiding himself, and then she zips him up, and they're both laughing. Still don't believe that. But then he gets upset because he can't breathe. I do believe that. And so then he's upset and yelling, which anyone would. Anyone would yell at someone to let them out first. By the time we see him on the video, he's pleading. He's begging. He's not angry anymore. He's put all of that down. He's stripped his ego. He is begging, baby, please let me out. This is serious. But she only remembers that anger. And she got mad because he got mad. Let's put that into perspective. The biggest, most abusive mindset I've ever heard in my entire life. I just cut off someone's oxygen. They're yelling at me. And now I'm pissed off that they're yelling at me. And I'm thinking about the times where they made me not be able to breathe. Again, she's omitting the time she strangled him. Never brings that up. So it's okay for her to choke him and put these big old black marks around his neck. But yet she can only remember the times he choked her. No memory of any time she ever hit him, harmed him, or whatever. And that's why it's so mind-blowing when she said, I thought it was the boy cry. I thought he was the boy crying wolf again. The again sent off every red flag imaginable. That is saying you have put him in dangerous positions like this before, and you haven't cared. You have called it crying wolf. I bet you called him crying wolf before you called the police after he kicked you in the face to get you off of him. But of course, you only took that as an assault to you. So you called the police, you tell them to go get him. Please put the fear of the police in him. He ragdolled me, this and that the whole time, never once mentioning that you were strangling him on the staircase. Which just makes this even more heartbreaking. How many times did this happen? How many times did she choke him? Did she take away his air. And I absolutely believe he probably choked her back, because he has admitted that he hits her. I mean, he's admitted either directly or indirectly that he hits her because she hits him. So if she's clawing, scratching, choking, I definitely can see a world where he starts choking her in the future. Not good, not justifiable, but it's not like she was this innocent victim that did nothing wrong and this just happens to her. All the injuries that track, most of it falls in line with reactionary violence or retaliatory violence. I have not seen much evidence that is out of nowhere, unprovoked. He came, left at me, just knocked me out. No reason, nothing. And then when you ask other people, it's, oh, she was harassing him this whole day. She was needling him. She was this, she was that. And it's not just her, right? Like, it is a two-way street between that relationship. However, she likes to throw the stone and then hide her hand and act like nothing happened, and then get shocked when you call out saying, didn't you just throw that stone that I saw was in your hand? What? And now she has to make herself the victim. Train knows who the real victim was as well. It's obvious to anyone who looks at this case and looks at the facts for what they actually are, that she has been the abuser in control of this entire situation. She broke her favorite toy that made her feel better about herself and that she could feel superior towards. She did not actually love him. Regardless of what she says, and regardless of what she even thinks, she may feel that she loves him. No, she didn't. She absolutely did not. She was in love with his idea, with what she could do with him, his purpose, but him, the person, not at all. It's impossible to be able to love someone and then to do what she did to him constantly. This isn't one of those, I was beat so many times that I just had that moment and I snapped and it came out of nowhere, but it was building up and I couldn't control myself and it just happened. This was bound to happen and everyone else saw it, especially his family, who kept saying they knew she was going to kill him. They knew it. Because the signs were there. Her behaviors were obvious. She was violent, out of control, knew how to manipulate systems, knew how to get things the way she wanted it to, and is willing to say anything and do anything to get the result she wants. And we see that again here.
So yeah, they're gonna know what we're here, what we're investigating, and that
They're gonna think I killed him.
Why would they think that?
They always have said that. They've always have said that.
What have they
I
said?
told you it's because I'm the blue-eyed white dragon. That's what they call me.
And she finally admits to using the bat. I wondered why that shift came up, because in the interrogation she said, oh, that's just for, why do people care about why did you guys get the bat? She knows why they got the bat. She knows why she's asking about the bat. And I bet when she finally had the look at the physical evidence and she saw the bat and what they were going to bring up, she said, I have to explain this away. So I got mad because he was complaining I was killing him when he choked me one time. I couldn't believe that. So I got angry and I shook the bat. She said it shook and it slipped out of my hand. She lost control. Slipped how? She wants it to say, and I do believe it did slip, she wants it to say she slipped and that's how it ended up face down. It would have to be propped up first to go face down. Unless you zipped him in while the suitcase was vertical, up and down, and not horizontal flat. But what I think is the truth is that her hands did slip, and that's why he fell down the stairs like that. I believe she was trying to get him down steps, but I don't think she wanted him to fall the way she did. I think she was just going to do it herself. She was too drunk, her finger slipped, and then he comes crashing down. And then she drags him from those stairs to the middle of the living room where we see her take the video. Because where the suitcase is on that video is far away from the stairs. The stairs are a little ways away, or it's like a little mini hallway. Not even a mini hallway. You just have to drag them to the center. It is not right next to each other. So he couldn't have fallen down the steps and then the suitcase land where it landed. He was drug over there. She probably tried to prop him up and it fell flat. That's why she started laughing, pulled out the camera, recorded, and then when she pulled out the camera again, it had flipped because she flipped it over after that and then took another video. There's so many actions in this that just scream of guilt. She could have stopped at any moment. She could have avoided this at any moment. There are so many times she could have intervened. She could have ran away, called for help. Like, she could have done so many things, and she did nothing but what she wanted to do, which was laugh at him, document it, and go to sleep. 19. Now, after having committed the independent forcible felonies of aggravated assault, aggravated battery, and the non-forcible felony of false imprisonment, the defendant believed the decedent would kill her. 20. Despite believing the decedent would kill her, the defendant flipped the suitcase over so it was right side up, and she believed the decedent would be able to let himself out. 21. The defendant's specific intent was for the decedent to feel like what it was like for her to choke and not be able to breathe. She intended for him to feel this for 2 minutes and believed he would let himself out. And when that happened, if she died, she died. What does that even mean? Oh my goodness. So she just undercut everything. Again, this wasn't self-defense because it wasn't intentional. One, you haven't said a single self-defensive measure that you've taken. You've talked about how him getting upset, triggered you and activated in you this memory of what he did to you, and that made you rageful. That is not self-defense. That is revenge. That is intentional premeditation. She's actually literally adding premeditation of, he got mad. I was remembering how he made me mad. So I started shaking the thing. I started hitting him. I started laughing at him. Premeditation can be gained in an instant. It is within that self-awareness. She is trying to intentionally cause him harm. She could have hit him with the bat and that could have knocked him out, cracked his skull, and he could have died from that. I don't think he did, and I'm not saying that's what happened, but that could have happened, and that would be first-degree murder. She had the intention of hitting him to cause harm, and he just happened to die from that. That would be first degree. Here, second degree, it's being called second degree because we don't believe she had the intention of killing him. No one believes that. I don't believe it. I don't believe that she intended to kill him. It was to torture him. It absolutely was. She even said it at the crime scene. I just wanted to make him squirm a little or whatever it is.
Forgetting that he was in the suitcase.
So you guys were playing the hide and go seek?
Yes.
And at some point you put him in the suitcase?
No, he got in the suitcase. So he thought it would be funny to be put in the suitcase. So I was like, okay, well, I'm going to joke with you and I'll zip you up and make him, squirm a little bit, whatever it is. But then I fell asleep. I fell asleep.
Where was the suitcase?
Right where it is.
Right down there?
Yes.
You zipped him in there?
Yes.
Thought he would be funny, a little joke?
It was. We both were laughing about it. And then I fell asleep.
As though she has the right to choose who gets to squirm and who doesn't, and what's justified and what isn't. She still thinks she's justified and that she's the victim, even though her lungs still expand every single day. But she's the victim. If she genuinely thought he could let himself out and that when he let himself out, he was going to come kill her, how the fuck did she go to bed that night? How the fuck did she go to bed so comfortably if she was so convinced he could get himself out, and that if he did get himself out, if she died, she died? What No one's going to believe this because it is unbelievable. And it's an insult to everyone involved. Of course, you have to still paint him as a murderer, even as you killed him. Like, what kind of sense does that make? To be able to laugh at your aggressor, taunt them, put them up, just assume that they would get out. And she actually said that in the car interview, she thought she was waiting for him to get out, come up, so that they could have sex.
He's in there. You said you could see 2 of his fingers?
Yes.
And then, like, you just decided, okay, I'm going to go upstairs now? Or?
Because I figured he would get out and then go upstairs and have intimate relations like we normally do.
What? That was her original the day afterwards. She said, I thought he could get out because I was waiting for him to come up so we can have sex, but the dogs were around me, I felt warm, and I fell asleep. That's you being terrified. That's you being self-defensive. And she's painting it in a way of, I still tried to do the right thing. Even though I was fearing for my life, I still flipped it over so I could give him a little bit of a chance, even though he's completely disoriented, drunk, beaten the fuck up, and still trapped in a suitcase. But, you know, I'm the good one because I still gave him a chance. And if he had gotten out, I was totally prepared to take the responsibility of just dying. Anyone believe that? 22. She did not intend to kill him, and she did not believe that leaving the decedent in the predicament she placed him in would kill him. ... His death was an accident. Legal analysis. 23. Battered spouse syndrome evidence is inadmissible if the defense is an accident rather than self-defense. Wagner v. State. The defendant's testimony is that she intentionally zipped the suitcase out of levity and while kidding around with the decedent during a friendly game of hide and seek. Then, when the decedent informed her that he could not breathe, she intentionally decided, out of anger, to make him feel like he's trapped in there for a couple of minutes while she beat and shook the suitcase and hit his hand with a baseball bat. This is aggravated assault, aggravated battery, and false imprisonment. She stated that she flipped the suitcase right side up, saw that the decedent could get 2 fingertips through an opening, and she went upstairs to bed, believing he would be able to get out in a couple of minutes. She had no intention of killing him, no intention to leave him trapped inside of a suitcase, and she did not even comprehend that he could die from this. The defendant is thus still saying that the decedent's death was an accident, and she is not entitled to an instruction on self-defense or to supplement a self-defense case with reputation evidence, specific instances of past violence, or battered spouse syndrome evidence. Lance v. State. 24. The defendant's statement that she perpetually lived in a state of fear of the decedent is not sufficient to allow for a self-defense instruction, and all of the ancillary evidence of reputation testimony, specific acts of past violence, or battered spouse syndrome testimony. Quote, however, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland v. State, quoting Quintana v. State, quoting Williams v. State, Reed v. State, Rudden v. State. Victim hit defendant with a 2-inch wide, 4-inch long stick in the hand, causing only minor injuries, did not justify defendant's use of deadly force. Comparing the facts of those cases, it is clear there was not even the slightest overt act by the decedent in this case. Mr. J did not come to play. He came with case law after case law after case law, even adding that example of even if he hit her that night, did not meet the standard of justifiable use of deadly force. She has to meet all of these standards. He did nothing to meet any of those standards of self-defense. Like I said, battered spouse syndrome is only there to justify why she kept herself in that abusive relationship, not to justify the self-defensive measure itself. And by all accounts, there was nothing for her to defend herself against except her own emotions. She got upset because he yelled at her for zipping him in a suitcase. Imagine you justify your rage because someone does not like that you confined them in a space that could kill someone. ... and did. 25. Prior to the defendant committing aggravated assault, aggravated battery, and false imprisonment, there was no imminent threat from the decedent. State v. Woodson, Morris v. State, you can't just attack somebody as they walk into their front door and slash their throat with a knife because 2 days prior they sent you a threatening text message. 26. If this evidence is improperly admitted, it would be a departure from the essential requirements of the law, which would result in irreparable harm that cannot be corrected by a post-judgment appeal. Roberts v. State. 27. The state acknowledges that the defendant is entitled to change her story yet again. So if the court does not exclude this evidence now, the defendant should be barred from mentioning battered spouse syndrome evidence until the defendant testifies to something that is justifiable use of deadly force. He said, we all know her ass is going to lie, so wait until she gets her lying ass on the stand and actually does the lying, and then she can lie some more. Ladd v. State. BSS evidence properly excluded until defendant testifies when that's the only source of information for the defense. Medina v. State. Not improper to exclude expert testimony until the facts are in evidence. Wagner v. State. BSS not available if the defense is accident rather than self-defense. I certify, William J. Robert. Wow. Hearing the state's theory, wow. And it looks like that is it for today. We have covered a lot in this video, and yeah, I'm going to post this as soon as I finish. It's going to be a late night post. You know, thank you all for who watch it. If you don't, hopefully you enjoy on the replay crew. But yes, trial starts, well, today, later today. It's really late right now. So trial starts later today. We are about to be on a roller coaster. I have no idea what to expect. And we'll have to see how this goes. She rejected a plea that would have gotten her out of jail within 6 years or less. Or could have if she, had good behavior, all that stuff. But no. She is shooting for complete exoneration or life in prison at this point. The 22.5 men is not going to happen. That is what you get if you have all the mitigating factors there. You got convicted of second-degree murder. My minimum is 22.5 years. You have all of these circumstances that prove you're not as dangerous as the conviction proves you are. Here's 22.5 years. You, Miss Sarah Paulson, are as dangerous as the crime that you will be convicted of is. There are nothing but aggravating factors about this. Zero remorse, lies upon lies upon lies, more lies and then more lies and then more lies. Pointing the finger, attacking other people, coming for the credibility of everyone involved, judges, legal aides, lawyers, it doesn't matter. They were in your line of fire. And so now you will be in front of Kranick's line of fire. But yeah, I'm excited to get this show on the road so that we can get done, we can get to sentencing, and I can put Miss Paulson in my rear view mirror, look on to greener pastures, and by greener pastures, I mean other horrific cases that you all want my opinion about. Speaking of, I just need to celebrate again. We just hit 6,000 followers. Mind blown. Thank you all so much. Still blows my mind every time. I can't believe it. I'm still happy you all are here. I I also actually started an email address. I created an email address. It's in my bio, shortkingreacts@gmail.com with a Z instead of an S. I will just say, don't expect a response there. Love to see it. Don't expect one. That's all I'm going to say. I will check it when I can, and I'll try to respond when I can. But just if you do send something, just assume that it will not be answered, but that my love is still with you. There's also a support link in the bio. Don't feel like you have to use it, but those things are now available. Thank you all so much. And with that, don't forget to like, comment, subscribe, dislike if you're feeling it. Until next time.
Thank you all for watching this here.